Good afternoon and welcome everyone to the 2023 PALS pre-week. I hope you are all excited to get started with today's scheduled lecture. Today is the first day of a month-long lecture series with different professors for the 8 bar subjects. And the date and time for succeeding events will be mentioned at the very end of this session. Now, please don't forget to like and follow our Facebook page, Rex Education and Philippine Association of Law Schools to remain updated with the dates and speakers for each of our program. Once again, I welcome you all to Bar Ops 2023 pre-week, a discussion on the frequently asked topics on the bar subjects, a project of the Philippine Association of Law Schools and Rex Education. Now today, it is an honor to introduce a person of extraordinary distinction. His accomplishments have left an indelible mark in the legal profession. From pioneering achievements to selfless contributions, he embodies the very essence of inspiration. His journey from humble beginnings to remarkable heights serves as a reminder that with determination, dreams are attainable. Yet, it is his commitment to giving back which truly sets him apart. Our esteemed speaker has shown us that true success is measured not only in personal triumphs, but in the positive impact we have on others. Our speaker for today earned his Bachelor of Laws in San Sebastian College, Recoletos de Manila School of Law. He is also a Master of Laws from the Pamantasan ng Lungsod ng Maynila Graduate School of Law and a Doctor of Civil Law from the University of Santo Tomas Graduate School of Law. He is also the founding Dean and Professor of Law of the College of Law at Tomas Claudio Colleges in Morong, Rizal, a Professor of Law and Chairman of the Remedial Department, Tarlac State University of Law in Tarlac City, Professor of Law and Chairman of the Remedial Law Department in New Era University College of Law in Quezon City, Professor of Law and Chairman of the Remedial Law Department in the University of the East San Sebastian College, Recoletos, Polytechnic University of the Philippines, Wesleyan Philippines, Cabanatuan, University of the Philippines College of Law, and Bulacan State University College of Law. He is also a professor in Remedial Law and a Faculty of Civil Law of the University of Santo Tomas and also the University of Makati School of Law and the Bicol University. He is a managing partner of the Moya II law firm. He is a legal researcher, an MCLE lecturer, mock bar examiner, bar reviewer, and author. Ladies and gentlemen, please help me welcome our speaker for today, the embodiment of excellence, Dean Salvador Moya II.
Okay, good afternoon viewers, good afternoon barristers. Isi-share ko muna yung Moya 3 because maraming nag-request sa akin as to whether or not I will demonstrate. Now, the Moya 3 combines jurisdiction both in civil procedure and criminal procedure. Now, in the last year's bars examination in 2022, I think first, second, and third questions, eksakto yung diniscuss natin. So I hope in one way or the other, makatulong ito sa inyo. Paki-share mo nga. Wala. So, makikita ninyo sa board. Okay? So, we start with jurisdiction. Jurisdiction is the power of the court to try, hear, and decide cases. Jurisdiction is vested by the Constitution and by law. The basic law on jurisdiction is BP 129 as amended by 7691 and further amended by RA number 11576. Now, as of now, and in September, when you take the bar, 11576 na. there is no more distinction as to the jurisdiction of the MTCs and the RTCs in Metro Manila and in the provinces. So in the board, makikita natin MTC, Municipal Trial Court, Metropolitan Trial Court, Municipal Trial Court in cities, and Municipal Circuit Trial Court. Now, Section 33 BP 129 as amended by 7691 and further amended by 11576. Personal action at 2 million pababa. Now, as you read the problem, disregard damages or charges, interest, attorney's fees. Concentrate on the principal amount. So if the principal amount is 2 million pababa, MTC ang jurisdiction. Now, how about real action? Okay? 400,000 pababa. Now, failure of the plaintiff to allege the amount involved, either personal or real action, is a ground for motion to dismiss under Section 12, letter A 1 to 3. Now, upon the effectivity of the amendment of the 97 Rules of Civil Procedure from Rule 6 up to 35, effective May 1 of 2020, Rule 16 was deleted and or transposed. However, while it is true that under Rule 15, Section 12, motion to dismiss is a prohibited pleading, there is an exception under letter A 1 to 3. Ano yun? Lack of jurisdiction over subject matter, litis pendentia, res judicata, and prescription. Now, saan makikita yung 400,000? Okay? So, assess value, makikita ito sa city or municipal assessor. Walang assess value, pwede niyong tingnan zonal valuation, saan makikita? BIR. Wala pa rin zonal valuation, documents executed by the parties. Wala pa rin value of the property of adjoining owners. So, it has to be alleged in the complaint. Now, can the court also motu proprio dismiss the case? Answer, yes. Pursuant to Section 1, Rule 9. Now, Section 1, Rule 9 shall be correlated also with Rule 14. Because as you file your case, the trial court, either MTC or RTC, is given 5 calendar days. Now, why is it that they're given 5 calendar days? Because under Section 1, Rule 9, in the event that the court lacks jurisdiction over the subject matter, there is litis pendentia, there is res judicata, and the action is already barred by prescription, the court can motu proprio dismiss the case. So sa court yon. Now, assuming na nakaligtaan naman ng court, wala kang nilagay doon sa assess value, wala kang nilagay kung ano yung zonal valuation or documents executed by the party, showing how much the value of the real property, wala ka rin inilagay na value as basis of the property of adjoining owners, the court can motu proprio dismiss the case. Okay? So, Section 33 yan. Now, ang sabi ko kanina, jurisdiction in appeal, kukumbine na natin para makatipid na kayo sa oras. May baon kayo that as you answer the bar question, mayroon kang sigurado talagang tama. So, rule on appeal, governing the appeal, MTC, going to the RTC, Rule 40. Now, akyat ka, RTC. Ano naman ang jurisdiction ng RTC? Personal action, 2 million plus 1. Kaya more than 2 million nilagay ko. Real action, 400,000 plus 1. So, more than 400,000. Okay? Legal basis, Section 19, BP 129, as amended by 7691, further amended by 11576. Okay? So, the same. Yung basis mo dito, yun din ang basis dito. Now, anong rule naman sa appeal? ang nakakasakop. Rule 41. Now remember that the RTC is not only a trial court, but it is also an appellate court. Kasi galing sa MTC, aakyat ka sa RTC. Hindi naman galing MTC, aakyat ka sa Court of Appeals. You will be violating the doctrine of hierarchy of courts. Now, 41, if the RTC is in the exercise of its original jurisdiction. Now, pag sinabi mong original, ibig sabihin, doon mo mismo ipinail yung kaso. Okay? Now, 42, if the RTC is in the exercise of its appellate jurisdiction. Because the appeal process will be different if the RTC exercise its jurisdiction originally or if the RTC exercise its jurisdiction as an appellate court. Magkaiba yon. So, 41, 42. Okay? Now, there are 3 constitutional bodies. Number 1, civil service. Number 2, COMELEC. And number 3, COA. Now, ang naiiba lang, hindi nakasama sa 64-65 ay ang Civil Service Commission. Okay? The Civil Service Commission is the central personnel agency of the Republic of the Philippines. It is the biggest employment agency. Under the Constitution on the Social Justice Clause, those who have less in life must have more in law. So therefore, if you lose from the Civil Service Commission, nasa Rule 43 siya. It is appealable to the Court of Appeals via petition for review. If you lose again in the Court of Appeals, you can elevate the matter to the Supreme Court under Rule 45 PQL on purely question of law. Exception to the rule that you can raise mixed question of facts in law, writ of amparo, writ of habeas data, and writ of kalikasan. Now, second, COMELEC. Ano jurisdiction ng COMELEC? National, regional, provincial, city. Example, national, PET, Marcos versus Robredo. You file it with the COMELEC if the PET or the Presidential Electoral Tribunal is constituted, the COMELEC is divested of its jurisdiction and it needs to transmit to the PET. National also, senator. So, if the SET or Senate Electoral Tribunal is already constituted, the COMELEC is duty-bound to transmit it to the SET. Now, Congressman, HRET, House of Representative Electoral Tribunal. Once it is constituted, ililipat ng COMELEC. Okay, you have regional, you have provincial, and you have city. Now, there are 2 divisions in the Commission on Election. Okay, first and second. You cannot go to the Supreme Court if you lose in the first or second division. You need to file a motion for recon to the COMELEC in bank as a condition sine qua non. Now, again, if you lose in the in bank, you can go to the Supreme Court under Rule 64 and 65. Grounds, grave abuse of discretion, kaya God. How many days do you have? You have 30. Now, is it extendable? The answer is no. Because the 30-day period is provided for by Article 9 of the Constitution. The rules of court cannot amend the Constitution being the fundamental law of the land and the highest law. Now, the decision of the COMELEC in bank is immediately executory. Now, as you elevate the case to the Supreme Court, you need to apply for a TRO, injunction, or status quo ante order. Absent the issuance of a TRO, injunction, or SQA, the decision of the COMELEC in bank shall be immediately executed. Example, Rosal versus Commission on Election. Rosal is the governor of Albay. Since the Supreme Court did not issue a TRO or injunction or a status quo ante order, then Rosal was removed from office and Lagman took over as the vice governor as governor of Albay. Now, what is the reason why the decision of the COMELEC in bank is immediately executory? Vox populi, vox Dei. The voice of the people is the voice of God. Now, punta tayo doon sa kanan, sa right side, Commission on Audit. Okay, Commissioner 1, Commissioner 2, then Chairperson. Wala namang bank dito. After the denial of your MR, ito yung tinatawag na COA proper. So after the denial of your MR, you can go to the Supreme Court. Also within the 30-day period. Anong ground mo? God din. Anong rule gagamitin mo? 64 in relation to 65. How many days do you have? 30. Extendable? No. It is fixed. Okay? Now, why is it that the decision of the COA is immediately executory? COA is the guardian of the purse of the people. Your money, my money. So therefore, it is immediately executory. Now, balik tayo sa court. Pag-akyat mo, Court of Appeals, sa kaliwa mo ay Sandiganbayan. There are 7 divisions in the Sandiganbayan. Then sa kanan mo naman, Court of Tax Appeals. There are 3 divisions at mayroong bank. Ano jurisdiction ng Court of Tax Appeals? 1 million pataas. Therefore, if it is below 1 million, you file it with the RTC. Now, how about Sandiganbayan? Jurisdiction of the Sandiganbayan are those officers or employees of the government with salary grade of 27 and above, and the crime was committed in relation to the performance of its official duties. Now, can private individual or those with salary grade below 27 be included and information be filed in the Sandiganbayan? Answer, yes, provided there is an allegation of conspiracy. Now, there are true landmark decision here. The case of Dilima versus Guerrero and the case of Ampungan versus Sandiganbayan. What happened in Dilima? Now, a case for violation of 9165 was filed against Senator Dilima with the Department of Justice. Dilima sent her team of lawyers and filed a motion to dismiss, questioning the jurisdiction of the Office of the Secretary of Justice, saying that when she was the Secretary of Justice, she has a salary grade of 31, and therefore, it must be the Ombudsman who must conduct PI. Now, after learning that an information was filed with the OCC of Muntinlupa City, Dilima filed a motion to quash information pursuant to Section 3 of Rule 117 on the ground of lack of jurisdiction. Now, the case was raffled off to the sala of Judge Guerrero. Now, instead of resolving the motion to quash, Judge Guerrero resolved whether there is a probable cause to issue a warrant of arrest. Now, before that, Dilima went to the Supreme Court via Rule 65, questioning the resolution or the findings, judicial findings of probable cause. Because accordingly, there is a pending motion, motion to quash. Upon reaching the Supreme Court said that the primary duty of a judge upon receipt of the information is not to resolve any motion pending, but the duty of the judge is provided for by Article 3, Section 2 of the Constitution. It provides that no warrant of arrest or search warrant shall be issued except upon probable cause to be personally determined by the judge after examination under oath and affirmation of the complainant and witnesses, particularly describing the place to be searched and the person to be seized. Now, remember also that there are 2 types of determination of probable cause. One is executive, made by the public prosecutor for purposes of filing an information. And 2, judicial determination of probable cause for purposes of the issuance of warrant of arrest. Remember also that you need to correlate this with the revised guidelines on continuous trial, which prescribe the filing of motion for judicial determination of probable cause. Because primarily, it is governed by the Constitution, and that is the primary duty of a judge. Number 1. Number 2, according to the Supreme Court, Dilima also violated the doctrine of hierarchy of courts. Because from the RTC, Dilima went to the Supreme Court, not to the Court of Appeals. So, dismiss yung petition for review niya. Now, there is also another case. Ampungan versus Sandiganbayan. Now, what is the case of Ampungan? Ampungan was the former city vice mayor of our hometown in Iriga City. There was a vacancy in the position of the Secretary of Sangguniang Panglungsod. Now, Ampungan requested that the Sangguniang needs a secretary. In view of the inaction of the Human Resource Department, on his own, Ampungan conducted a recruitment. He also invited the majority members of the Sangguniang, but they did not attend. After the appointment was transmitted to the Civil Service Commission and it was attested, case was filed against Ampungan. Violation, usurpation of authority, falsification of public document, and violation of RA 3019E. Now, in the Ombudsman conducted PI and the information was filed with the Sandiganbayan. Ampungan filed a motion to quash on the ground of lack of jurisdiction under Section 3117. Sabi ng Ampungan, Vice Mayor lang ako. Ang salary grade ko ay 26 lamang. So dapat, it has to be filed, if any, with the RTC of Iriga City. It was denied by the Sandiganbayan, MR denied, Ampungan went to the Supreme Court under Rule 65 on the ground of grave abuse. Per Mr. Justice Peralta, later to become Chief Justice, regardless of the salary grade, if it is violation of RA 3019, pursuant to the original charter of the Sandiganbayan Presidential Decree number 1606, the Sandiganbayan has jurisdiction. It is an exception to the rule. Now, the rest is history. Ampungan was acquitted by Sandiganbayan. I just don't know whether it is by fate or coincidence. Dilima is from San Agustin, Iriga City. Ampungan is from San Isidro, Iriga City. And I am also from San Nicolas, Iriga City, Camarines Sur. Now, we go to the Court of Tax Appeals. There are 3 divisions in the Court of Appeals. Jurisdiction, 1 million and above. Now, if you lose in the first, second, or third, you cannot go to the Supreme Court directly. You need to file a petition for review to the bank within the 15-day period. After the denial of the petition for review, then you can go to the Supreme Court under Rule 45 on purely question of law. Okay, so tapos natin, i-discuss lang natin, then magdo-drawing ako. Kaya dapat sundan ninyo ako. Now, Supreme Court, there are 3 divisions in the Supreme Court, first, second, and third. Ano naman yung isa sa landmark decision dito? Now, this is the case of Laya Jr. versus Philippine Veterans Bank. Ano nangyari dito? Laya Jr. was the former head of the legal department of the Philippine Veterans Bank. PBB offered an ERP or early retirement program. At that time, Laya Jr. was 56 going 57. So he did not avail. Now, when Laya Jr. did not avail, he was dismissed. Laya Jr. filed an illegal dismissal case in the NLRC. Talo siya sa labor arbiter. Appeal to the NLRC, affirmed. Now, remember that the decision of the NLRC is final and executory. So you go by Rule 65 to the Court of Appeals. Akyat siya sa Court of Appeals, talo pa rin. Now, unperturbed, Laya Jr. went to the Supreme Court. Rappelled out to the First Division, talo ulit. So, talo na ba siya? Now, Laya Jr. opted to file a motion to refer the case to the bank. And the bank accepted the case. Per Mr. Justice Bersamin, later to become Chief Justice, an ERP or early retirement program is voluntary and not compulsory. So the decision was reversed. Nabayaran si Laya Jr. Clear ba ako na napuputol? Am I clear, Rex?
Yes, Dean. Okay naman po. Kanina lang po medyo napuputol-putol po. Pero ngayon okay na po.
Baka sa bilis ng salita ko, natakot yata yung microphone natin. Okay, babagalan ko ng konti. Okay, Laya Jr. Now, when can the case be referred to the bank? Is the in-bank an appellate court higher than the Supreme Court? Answer no. Decision of the Supreme Court, either by a division or by a bank, cannot be revised, reversed, or modified except through an in-bank decision. Now, the case can be referred to the bank. There are 11 reasons. Some of which are purely question of law. Transcendental importance. To render substantial justice. To serve as guidance for the bench in the bar, etc. So, the case was accepted by the bank and it was, or it reversed the decision and declared that ERP or early retirement program is only voluntary and not compulsory. Now, I think you are also aware, very much aware, with the case of Napis versus Court of Appeals or the press period rule. Now, mamaya, i-discuss din natin as to whether or not the press period rule applies also in criminal cases. Okay? Now, I have limited time so kailangan talaga bilisan ko para mas marami kong ma-discuss sa inyo. In the regular review program, binibigyan ko yung estudyante ng 5 minutes para at least kopyahin nila yan kung gusto nila. Ngayon, kung nakikinig lang naman kayo, okay lang naman. If you have a retentive memory. But I advise you na after this, mamaya kung may natutunan ka rito, dalawa kasi ang matitipid mo. Number 1, malalaman mo yung jurisdiction. And number 2, mamamaster mo yung appeal. So pag natapos natin ito, I will entertain at least 5 questions kung hindi nyo gaanong nakuha. Now, punta na tayo rito. Magdo-drawing na tayo. MTC. Okay? Now remember, kasama sa MTC, cases covered by the RSP or the Rules of Summary Procedure. Now, isa dito ay Rule 70. Rule 70, dalawa. Isang forcible entry saka isang unlawful detainer. Sa forcible entry, from the very start, illegal yung possession or occupation of property through force, intimidation, strategy, or steal. Now, sa unlawful detainer naman, legal from the beginning, it becomes illegal after the demand to vacate and demand to pay. So, covered siya ng RSP. Now, also, small claims, kasama rin dito yung expedited proceedings. Now, RSP cases, MR is a prohibited pleading. However, this was already interpreted by the Supreme Court. Anong MR ang prohibited? Sa decision, final order, or resolution, or judgment. So therefore, interlocutory order, meaning it does not finally dispose the case, MR is not a prohibited pleading. So, assuming na regular procedure tayo, natalo ka sa MTC, MR mo denied. How do you appeal? Okay? You go to the RTC merely by filing a notice of appeal plus payment of docket fee within 15 days. Okay? Is the filing of the notice of appeal extendable? Answer no. Nakapix yan. Now, remember that it is not only the filing, but it must be coupled with the payment of docket fee pursuant to the landmark decision in the case of Sun Insurance Company versus Judge Maximiano Asuncion. Now, mayroong nagtanong, how about if the docket fee is insufficient? Nagbayad, kunit kulang. It is the duty of the clerk of court through the sheriff that in the event that a favorable judgment is given by the court, it must serve as a first lien. Okay? Lagi kong sinasabi sa mga reviewee ko at mga estudyante ko, talk like a lawyer, write like a lawyer in order to become a lawyer. So, tandaanan, first lien. Okay. tapos na agad yung papel mo. Kasi MTC ito. Yung Rule 40. So punta tayo ngayon sa RTC. Ibig sabihin, ito ang jurisdiction ng RTC. So anong rule ang gagamitin mo? 41. Natalo ka. MR mo denied. Napis. Okay? Aakyat ka ngayon sa Court of Appeals. Okay? What should you do? Notice of appeal plus payment of docket fee within 15 days. Okay? So ano ang technique? Ang titingnan nyo, saan mismo ipinail. Ipinail sa MTC, notice of appeal. Ipinail sa RTC, notice of appeal. 15 araw lang yan. That is inextendable. Now, sabi natin kanina, RTC is not only a trial court, but it is also an appellate court. So galing MTC, inakyat mo sa RTC, talo ka ulit. Anong rule ang gagamitin mo? Rule 42. If the RTC is in the exercise of its appellate jurisdiction, how do you appeal? Okay? So you go to the Court of Appeals by filing a petition for review. How many days do you have? 15. Is it extendable? Yes. Plus 15 equals 30. What should you do? Motion for extension plus payment of docket fee para magkaroon ka ng maximum na 30 days. Now, when do you file the motion for extension? Now, the motion for extension class must be filed within the 15-day period. Otherwise, the decision will become final pursuant to Rule 36 in relation to Section 1, Rule 39. Okay? So, nasa Court of Appeals na yung kaso. Andito na siya ngayon. Remember that before elevating the case to the Supreme Court, either Rule 45 or Rule 65, motion for recon is a condition sine qua non. So, MR mo denied. Aakyat ka ngayon sa Supreme Court. Okay? Now, remember, there is only one rule, Rule 45. How many days do you have? And what is the proper term for Rule 45 versus Rule 65? Now, Rule 45 is a continuation of the case. Kaya nga dito, pinakita natin. Yung Rule 44, that is administrative procedure. What do you do in the Court of Appeals? Ilang appellant's brief, ilang kopya. Appellant's brief, ilang kopya. Sino ang ipo-furnish mo? Etc. So, hindi naman kasama yan. Now, 45. Now, it is properly termed as appeal by petition for review on certiorari. How many days do you have? 15. Is it extendable? Yes. Plus 30 equals 45. Rule 45. O paano ka magkakamali? Now, what should you do? Para magkaroon ka ng additional 30. Motion for extension plus payment of docket fee. Which you need to be done within the 15-day period. The Supreme Court already interpreted that the period, reasonable period is 15 days. For the reason na pag lumagpas yung 15-day period, magiging penal na yan. Okay? Now, you raise only purely question of law. Okay? Exception to the rule. Uulitin natin. Writ of amparo, writ of habeas data, and writ of kalikasan. You can raise mixed question of facts and law. Okay? So tapos, yung straight mong ganito, mas madaling intindihin. Tapos yung 41 mo, tapos yung 42 mo, tapos yung 45 mo. Now, exception to the rule, mayroon dyan na 30 days in case of multiple appeals. What is the reason for that? Kasi hindi naman yan represented or record on appeal. Hindi naman kasi represented yan ng isang abogado. Hindi naman pare-pareho yung date ng receipt niyan ng adverse decision niya. Kaya binibigyan ng longer period. Now also, from the RTC, may nagtanong din, pwede pa niya diretso na sa Supreme Court? Answer yes, if it is purely question of law. Because what you raise in the Court of Appeals is mixed question of facts in law. If you only raise question of law sa Court of Appeals, the Court of Appeals has no jurisdiction, your appeal will be dismissed. Okay? So, clear tayo. Now, punta naman tayo sa Court of Tax Appeals. So, mayroon siyang tatlong division. First, second, third. Jurisdiction niya, 1 milyon pataas. Natalo ka sa first, second, or third. What should you do? You go to the bank by filing a petition for review within 15 days. Natalo ka uli sa bank. Okay? What should you do? You can go to the Supreme Court. Rule 45. Ulit, 15 days plus 30 equals 45. Rule 45. What should you do? Motion for extension plus payment of docket fee. So, hindi pwedeng galing sa division. Direkta ka na sa Supreme Court. Hindi pwede yon. Okay? You will be violating the doctrine of hierarchy. 18. Paano kung below 1 million? Where do you file it? RTC. Okay? Natalo ka sa RTC, aakyat ka ngayon sa CTA, notice of appeal lang yan. Within 15 days plus payment of docket fee. Natalo ka, first, second, or third. Then you go to the bank. Petition for review. Natalo ka uli. Punta ka uli. Supreme Court, Rule 45. Maliwanag. So, that is clear. Crystal clear. Now, punta naman tayo sa Sandiganbayan. Okay? So, Sandiganbayan, there are 7 divisions. Natalo ka. MR mo denied. Regardless of the penalty imposed by the Sandiganbayan, in going to the Supreme Court, since Sandiganbayan is exercising its original jurisdiction, meaning, doon mo mismo ipinal sa kanya. You merely file a notice of appeal plus payment of docket fee within 15 days. Okay? Regardless of the penalty. Now, below salary grade 27, halimbawa plunder, ipinail ngayon sa RTC, convicted ka, MR mo denied, akyat ka ngayon sa Sandiganbayan. Ano gagawin mo? Notice of appeal lang. Okay? Plus payment of docket fee within 15 days. Okay. Mag-iiba ngayon. Okay? If the penalty imposed by the RTC is reclusion perpetua or life imprisonment, affirm ng Sandiganbayan, aakyat ka ngayon sa Supreme Court, notice of appeal. What is your legal basis for this? Section 3E, Rule 122, in relation to Section 13C, Rule 124. Okay? But later, I will discuss the February 2022 decision in the case of People versus Olpindo, penned by the Chief Justice in bank decision. Kasi nagkakaroon ng kalituhan dito. Mamaya, sa criminal naman. Now, if the penalty imposed is reclusion perpetua or life imprisonment, affirmed by the Sandiganbayan, notice of appeal pa rin. Okay? Within 15 days. Now, kailan ngayon mag-iiba? If the penalty imposed by the trial court as affirmed by the Sandiganbayan is less than reclusion perpetua or life imprisonment, in going to the Supreme Court, you will utilize Rule 45. PQL ka. Purely question of law. Okay? Clear tayo. Now, we go to the civil service. Okay? Quasi-judicial body ito. Now, per the case of Laguna Development Construction Corporation versus Rose Inc. SIAC hindi nakasama dito. Okay? Now, pagka adverse ang decision ng SIAC, grave abuse, Rule 65 ka, CA, Now, if it is purely question of law, Rule 45 ka, Supreme Court ka. Hindi nakasama rito sa 43. Now, dyan sa caudal ninyo, kasama pa rin dyan yung CTA. Hindi na. Wala na yan dito. Yung CTA. Okay? Hindi na kasama dito. Because CTA is now co-equal with the Court of Appeals and the Sandiganbayan. Puro na justices yan ang nandyan. Now, balik tayo, civil service. MR mo denied. Okay? Now, saan ka ngayon pupunta? Pupunta ka ngayon sa Court of Appeals. What should you do? Petition for review. How many days do you have? 15. Is it extendable? Yes. Plus 15 equals 30. What should you do? Motion for extension plus payment of docket fee. Para magkaroon ka ng maximum na 30 days. Okay? Talo uli sa Court of Appeals. MR mo denied. Akyat ka ngayon sa Supreme Court. Anong rule? Rule 45. PQL. Purely question of law. Okay? So tapos natin. Doctrine of double appellate review. Review ng CA, review uli ng Supreme Court. Social justice clause of the Constitution, those who are blessed in life must have more in law. Okay? Now, punta tayo sa COMELEC. Jurisdiction, national, regional, provincial, city. Natalo ka. First, second. Ano gagawin mo muna? You go to the bank. Okay? You file an MR within 15 days. Okay? Talo uli. Affirm yung decision. Saan ka ngayon pupunta? Supreme Court. Okay? Ano ground mo? God. Grave abuse of discretion. How many days do you have? 30. Extendable? No. Nakapix yan. What should you do to stop the decision? You need to apply for TRO, injunction, or status quo anti-order, SQA. Absent TRO, injunction, status quo anti-order, the decision of the COMELEC shall be executed. Vox populi, vox Dei. The voice of the people is the voice of God. Okay? Now, punta tayo sa Commission on Audit. Okay? So, talo ka. MR mo denied. Saan ka pupunta? Supreme Court. Okay? Anong rule? 64-65. Anong ground? God. How many days? 30. Extendable? No. What should you do? Apply for TRO, injunction, or SQA. No TRO, no injunction, no status quo anti-order. The decision shall be immediately executed. So ilang rules ang natipid natin? 40, 41, 42, 43, 44, 45. And also 64, 65. Yung 64, wala namang silbihan kundi COMELEC lang sa CACOA. Tingnan ninyo yung title. Kaya nga, nakalagay dyan doon sa post-judgment remedies. Tingnan ninyo yung syllabus. Kasama yan doon. Now, i-discuss ko yung para makatipid na rin tayo. What are the post-judgment remedies? Kasi class, ganito yan. Rule 1 to 39 is the rules of civil procedure. Kasi yung 39, kung titingnan ninyo, there are 48 sections. Pinakamahaba sa lahat ng rules sa civil procedure. Tapos na dapat kasi may execution na. So, ang civil procedure talaga, rules 1 to 39. Reason, 40 up to 56 ay appeal. Okay? Now, pag tiningnan mo yung 46 saka 56 letter A, yung 46 is the original action in the Court of Appeals. Okay? 56A, original action in the Supreme Court. Remember that the RTC Court of Appeals in the Supreme Court has concurrency of jurisdiction over petition for certiorari, provision, mandamus, quo warranto, habeas corpus, and the 3 special rules. Writ of amparo, writ of habeas data, and writ of kalikasan. Okay? Now, ano yung post-judgment remedies? Pag sinabi mong post-judgment, tapos na. May judgment na. So, number 1, motion for reconsideration. Motion for new trial or motion for reconsideration. Nandoon yan sa Rule 37. Yung Rule 37 class, you can also correlate to Rule 52 and 53. Ano yung Rule 52 and 53? 52, new trial. 53, motion for recon. Pareho din ang ground yan. Yung 52, 53, appeal cases. Yung nandito ngayon sa 37, kasi yung 36 ay judgment, nandito ka sa trial court. Okay? So, ano yung unang post-judgment? Motion for reconsideration or motion for new trial. Remember, 15 days yan. Okay? It is inextendable. There is no such thing as motion for extension of time to file MR. As early as in the case of habaluyas or otherwise known as the habaluyas doctrine. Okay? Ano yung pangalawa na post-judgment remedy? Appeal. Okay? So, diniscuss na natin yung appeal. Post-judgment. Remember that you need to do it within the 15-day period. Otherwise, the decision will become final and executory. Kaya nga, yung motion for extension mo, ay ginagawa mo sa loob ng 15 days. Because otherwise, the decision will become final under Rule 36 in relation to Rule 31, Rule 39, Section 1. Okay. Ano yung pangatlo na post-judgment remedy mo? 38, relief from judgment. Now, ano yung pinaka-importante sa 38? The double period rule. Ano yung double period rule? 60 days from learning and 6 months from entry. Okay? Ngayon, saan mo na ngayon makikita? Saan ba nangyayari yon? If the dependent is declared in default. When can the dependent be declared in default? If the dependent failed to file an answer or responsive pleading within the 30-day period. Natural person, you have 30. Extendable to another 30. Maximum of 60. No further extension. Juridical person, 60. Extendable to 30. No further extension. Original period, 15 under the old rule. Ngayon ay 30 na. 30, 30, 60, 30. Now, nakatatlo na. Okay? Pangapat, yung 64, post-judgment remedy din yun. Although, 30 days lamang. Diniscuss na natin. Ano yung panglima na post-judgment remedy? It is called the last and equitable remedy. Now remember, doon sa relief from judgment, ang ground mo ay PAMIN. Fraud, accident, mistake, excusable negligence. 60 days from learning, 6 months from entry of judgment. Now, ano yung last equitable remedy? Rule 47. Annulment of judgment. Ano ang ground mo? Lack of jurisdiction, extrinsic fraud, and jurisprudentially, lack of due process. Ano yung period? 4 years. Except if it is barred by laches. Tapos agad natin yun. Yung period, yun ang importanteng maintindihan ninyo. 46, 56. Pinagtapat na yan. Okay. Another correlation. Rule 18. Pre-trial. Correlated with Criminal Procedure 118. Is it mandatory? Yes. Sinadya kaya? 18 sa civil, 118 sa criminal. O parehong ending 8 kung marunong kang mag-observe. Now, what is the innovation doon sa civil procedure? Question, after the pre-trial, can the case now be submitted for decision? The answer is yes. Take a look at your Section 6, Rule 7. Correlate it with Section 10, Rule 18. As you file your complaint in your answer, kumpleto na kasi yung class. Mayroon ka ng testimonial via judicial affidavit, nandoon na yung documentary mo, nandoon na yung object evidence mo. Okay? Now, what do you do during the pre-trial? Number 1 is stipulation of facts. definition of the issues, number of witnesses to be presented. Now, sa pre-trial, nung old rule, pre-trial itinatapon sa PMC, Philippine Mediation Center. Ngayon hindi. Nagpi-pre-trial na muna, then the case will be transmitted to the PMC. Mayroon lang silang 30 calendar days. In case of failure, balik ngayon sa court, magkakaroon ng JDR, mayroong 15 calendar days. And in case of failure, the case now will proceed to trial. Now, under Section 10 of Rule 18, after the pre-trial, the case can either be submitted for decision under Rule 34 on judgment on the pleadings or Rule 35 on summary judgment. When can there be judgment on the pleadings? If the answer does not tender an issue. When can an answer? When can you say that the answer does not tender an issue? When there is a general denial. Because what is required under the rules is a specific denial. So, what is the effect if there is a general denial? That is equivalent to negative pregnant. What happens if there is a negative pregnant? It is equivalent to admission. When there is an admission, the answer does not tender an issue. And therefore, it could be subject to judgment on the pleadings under Rule 34. Remember, under Section 6 of Rule 7, kumpleto na yung mga dokumento. Now, while it is true that the answer tender an issue, but the only remaining issue is as regards to damages. And therefore, after the pretrial under Section 10, the case now can be subjected to summary judgment under Rule 35. Marami na tayong rules na na-discuss. Sigurado naman ako may lalabas dyan. Imposible namang walang lalabas dyan. So, I will entertain, ipapabura ko na to. Do you have any question? Mga 5 tanong para discuss uli natin yung criminal procedure. Pakibura mo na nga. Tapos natin yung Moya 3 sa civil procedure. Mas maganda yung criminal procedure. Tapos punasan mo ng basahan. Is there any question sa viewers natin? Pwede ninyong kung ano yung tanong ninyo. Masyado bang mabilis? Kailangan kasing mabilisan ito. Kasi limited time lang tayo. So kaya as much as possible, gusto kong iunat at gusto kong i-correlate yung mga rules natin. So remember 52, 53. So take a look at also 37, then 36, judgment, Rule 18 versus Rule 118. Pareho lang yan. Criminal. Now another thing class, Rule 33, demurrer to evidence versus Section 23 of 119, demurrer to evidence in criminal cases. What is the effect? So pagka demurrer sa civil, the case will be dismissed. If on appeal it is reversed, the right of the defendant to present evidence is forfeited. Now, how about demurrer to evidence in criminal cases? You can file it in two ways. Two ways. One, demurrer without leave of court. If it is denied, you forfeit your right to present evidence. The case will be decided based only on the evidence of the prosecution. If you file a demurrer with leave of court, and it is denied, the accused shall be given a chance to present evidence. Now, if the demurrer to evidence is granted, that is equivalent to acquittal. And therefore, double jeopardy attaches. Okay na? Means that it does not finally disposes the case. Klaro? Kanina sinabi ko yun. Prohibited lang kapag ka sa judgment or decision.
Another question.
Sige.
Another question po din from Miss Cherry Chow. Can the filing of a motion for reconsideration stay a decision po?
The answer is yes. Okay. A decision becomes final and executory after the lapse of the 15-day period without the losing party filing a motion for recon or an appeal. Now, binibigyan ka ng 15 araw. So if within the 15-day period, hindi ka nakapag-file ng MR, hindi ka rin nakapag-file ng appeal, final na yun.
Another question po din from Miss Michelle Ablan. The rules on summary procedures, small claims, and expedited summary procedures are different po ba sa ordinary jurisdiction ng first level court?
Lahat yan nasa first level lang. First level court lang yan, yung tatlo. Okay? Lahat ng summary procedure, small claims, kaya nga saan ka nakakita ng small na big? Di ba? So, small claims, lahat yan sa first level courts. Okay? Yung jurisdiction niya.
Thank you po, Dean. Meron pa po isa. From Mr. Antonio Bermejo. What is the immediate remedy for the release of the person charged for drug cases served for crime po? For already 10 years with GMC of more than 5 years. Crime po.
Baka actual case na yan, mayayari tayo. Ibibil na kita ng attorney's fees niyan. Academic ano lang tayo. Okay, saka hindi pa ako nagdi-discuss ng criminal procedure. Antayin mo muna itong i-discuss ko sa Crimpro, okay? Saka ka magtanong. Yung kanina, civil procedure. Ikinumbine ko lang kasi yung Sandiganbayan kasi nga hindi naman natin may iwasan na wala yon. Okay? So, i-discuss ko muna, mamaya sasagutin ko. Okay?
Meron pa po, Dean.
Fair sa mga viewers natin. Alvin, ano?
Meron pa po, Dean, from Mr. Joselito Panahon. Question po sa application of notice of appeal and order of appeal. How it is applicable in civil procedure, on what stages, before judgment becomes final and executory, or after judgment becomes final and executory? Thank you po.
Okay. Di ba diniscuss ko kanina, judgment, order, decision becomes final and executory after the lapse of the 15-day period. Pag sinabi mong after, on the 16th day. Now, if within the 15-day period, nakapag-file ka ng notice of appeal, hindi yan magiging final. Now, remember that it is not only the filing, inuulit-ulit ko, but it must be coupled with the payment of docket fee. Okay? Pursuant to the landmark decision, in the case of Sun Insurance Company Ltd., versus Judge Maximiano Asuncion. Ipapile mo within the 15. Kasi pag lumagpas ng 15 yan, final na yun. Okay. Di ba doon naman sa petition for review sa 43 o kaya petition for review sa 42? Di ba pwedeng i-extend? Okay, mag-file ka ng motion for extension plus payment of docket fee. However, the motion for extension must be filed within the 15-day period because after the lapse of the 15-day period, final na. Ano pa i-extend mo? Wala na. Oh, clear? You need to file it within the 15-day period bago lumagpas. Now, okay. First day excluded, last day included. Now, na-receive ng abogado mo yung decision July 15. Na-receive mo yung decision July 10. Saan mag-i-start yung counting ng 15-day period? Ano ngayon yung rule? Notice to the client is not notice to the counsel. Notice to the counsel is notice to the client. So therefore, sa July 15, ano rule? Exclude the first day, include the last day. Kailan mag-i-start yung 15-day? Sa July 16. 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. Hanggang July 30 yung 15 days. Oh, clear?
Dean, meron pa po tayong dalawang question. Good PM Dean, sa Rule 42, question niya, 15 days plus 15 days plus 15 days? Thanks po, to clarify lang po na 45 days lahat.
Yan. 30 days lang sa 42. Hindi siguro inabutan yung drawing. Yung 45, sa Rule 45 din. Originally, sa Rule 45, mayroon kang 15 araw. 15. Ngayon, pwede bang mag-file ng motion for extension? Answer, yes. You need to file it within the 15-day period. You can be given an extension of 30 days. 15 plus 30, 45. Sa Rule 42, Rule 43, 30 days lamang. You file the motion for extension within the 15-day period. You also pay the corresponding docket fee within the 15-day period. You will be given an extension of 15 or a maximum of 30 days. No further extension. Okay?
Thank you po din. Last question from Miss Lizelle Banzuela. If motion for writ of execution sa labor arbiter enacted for 6 months, ano po ang best remedy?
Itanong mo yan doon sa reviewer nyo sa labor. Malamang actual case yan. Wag na. Class, hindi sa nagiging maigpit. Wag na nating itanong yung actual case, kung kaso nyo yan. Yung academic discussion natin is to help barrister pass the bar or we contribute a little para makapasa. Ngayon, you want to ask questions pertaining to labor in deference to your lecturer on labor, dun yun na itanong. Yung sa akin sa remedial lang. Civil, criminal, yung tinanguan ko sa Rex saka sa PALS. Okay? O, pasensya na. Yung mga ganyan, wag nyo na itanong sa akin. Otherwise, you can go to our law firm and I will give you a lawyer for consultation. Okay? Sige. Magdo-drawing lang ako sandali. Okay, Rex, clear ba yung nasa whiteboard? Malinaw, Rex? Rex monitor, clear ba tayo?
Yes, Dean, clear naman po.
Okay, clear. Now, we start with discussion. Section 2 of Rule 112 was amended effective October 3, 2005. Tingnan ninyo, yung codal ninyo, baka madaya kayo. Now, effective October 3, 2005, the following officers may conduct a preliminary investigation. City, provincial, and their assistant prosecutors. Regional or state prosecutors. Ombudsman and other officers as may be authorized by law. Now, who are these other officers? These are the legal officers of the Commission on Election who are members of the bar. They can conduct a preliminary investigation insofar as violation of election offenses is concerned. So, comes October, mayroon tayong barangay and SK election. In other words, class, municipal trial court judges are no longer allowed to conduct PI. Now, Section 1, makikita ninyo dito, Section 1, 110, in relation to Section 1, 112, if the crime committed is punishable by at least 4 years, 2 months, and 1 day, PI or preliminary investigation is a matter of right. Contra, therefore, if the crime committed is punishable less than 4 years, 2 months, and 1 day, then PI is a matter of discretion. Example, BP 22. BP 22 is covered by the RSP. So therefore, it is discretionary on the part of the public prosecutor if they will conduct PI or not. Okay. Now, effective October 3, makikita nyo sa kaliwa, saka sa kanan ninyo. Ito na lang na dalawang ito ang nagkakandak ng preliminary investigation. ACP, APP, Assistant City Prosecutor, Assistant Provincial. Ipinapile yung kaso kung sa city ka, Office of the City Prosecutor, irarapol, mapupunta sa ACP. Kung ikaw ay nasa probinsya, Office of the Provincial Prosecutor, meaning outside of the city. Example, sa Bulacan o taga Bukawi ka. Pero kung taga Malolos ka, city na, o may kawayan ka, city na, doon ka na mismo magpapile. Bakit? Mayroon na silang Office of the City Prosecutor. Now, kung sa probinsya, ibababa dito sa Assistant Provincial Prosecutor. Now, akyat, PG. Ano yung PG? Prosecutor General. Dito lang yan sa Metro Manila. Kasi wala naman sa Metro Manila Regional State Prosecutor. Yung RSP sa probinsya. Anong rule ang nag-govern? DOJ Circular 018-14. Akyat, SOJ. Okay? DOJ Circular 70, DOJ Circular 70-A. Akyat uli, isa, OP, Office of the President. So ito yung hierarchy ng piskal. Okay? Now, doon naman sa kanan, if the salary grade is 27 and above, and the crime was committed in relation to the performance of official duties, even those below salary grade 27, even though you are a private individual, if there is an allegation of conspiracy, you can file it before the Office of the Ombudsman. Okay? Now, overall Deputy Ombudsman, nandito yan sa Quezon City. Kung ikaw ay taga Luzon, ipinapile yan sa Quezon City, Deputy Ombudsman for Luzon. Kung ikaw ay nasa Visayas, Deputy Ombudsman for the Visayas, nasa Cebu yan. Kung ikaw ay nasa Mindanao, Deputy Ombudsman for Mindanao, Cagayan de Oro yan. Then Muleo, military, and other uniformed personnel, Quezon City yan. Now, GI, Graft Investigator. Kalinya siya nung piskal. Okay? Ombudsman, ito yun. Isa lang naman ang ombudsman. Okay? Now, balik tayo dito sa gitna. Jurisdiction. Okay? Ano ang jurisdiction ng MTC sa criminal cases? All criminal cases with imposable penalty of 6 years and below. Now, rule on appeal, hindi nagbabago. Rule 40 din yan. You can take a look at your section 2 of Rule 125. Basahin ninyo. That appeals in civil and criminal cases are the same. Okay? Now, RTC, ano ang jurisdiction niya? Crimes punishable by more than 6 years. Kaya nga, 6 plus 1. Anong rule sa appeal? 4142 in relation to Section 3E 122, Section 13C, Rule 124, if the penalty imposed is reclusion perpetua or life imprisonment. Akyat, Court of Appeals, then you have Sandiganbayan, pareho ang discussion. Ililihis na natin. Yung Dilima nandyan, yung Ampungan nandyan din. Now, Court of Tax Appeals, ganun din. Ano ang basehan? Magkano ang involved? Tax evasion, or insufficiency payment, etc. Ang titingnan mo, magkano? So, doon may papile sa city pag 1 milyon pataas. Below 1 million, ipapile mo sa RTC. Then, you have the Supreme Court, first, second, third. Okay? So, 45 din, PQL, purely questionable law. Exception to the rule, Rita Bamparo, habeas data, kalikasan. Okay? Now, i-discuss muna natin yung dalawang controversial na kaso dito sa MTC. So, first, yung Conquilla versus Bernardo, 2011 decision. Remember that Section 2 of 112 was amended. Effective October 3 of 2005. Removing from the MTC judges to conduct preliminary investigation or preliminary examination for that matter. Now, a case was filed with the MTC of Bukawi, Bulacan. Judge Bernardo conducted a PE and after findings of probable cause, issued a warrant of arrest. The accused filed a case for gross ignorance of the law against him. And he was penalized by the Supreme Court for the reason that effective October 3, 2005, MTC judges can no longer conduct PI. Okay? Conquilla versus Bernardo. Now, another case, it involves prescriptive period. Okay? Act number 3326. So, violation of city or municipal ordinances and special laws. The prescriptive period class is governed by 3326. The filing of the complaint with the prosecutor's office does not toll the running of the prescriptive period. Ano nangyari dito? Illegal parking sa Baguio. Instead na bayaran yung penalty, pinailan ng kaso, nag-participate sa PI, lumagpas yung 60 days hanggang makarating sa Supreme Court. Because the prescriptive period for violation of city or municipal ordinances is only 60 days. Pag lumagpas yung 60 days, and the information is not filed in court, it is now barred by prescription. Okay? So, parang galit na galit si Justice Leonin dito doon sa decision. That's how Filipinos are litigious. We are very litigious persons. Imagine, parking lang, illegal parking, makakarating pa sa Supreme Court. Kung binayaran mo na lang, 1.5, o kahit sabihin mong 2.5, illegal parking, magkano ba ang docket fee? O makakarating ka pa sa Supreme Court? So, Jadwell parking system versus Lidua. Okay? The filing of the complaint for violation of city or municipal ordinance in the prosecutor's office does not toll the running of the prescriptive period. Okay. Ito naman, kanina, mayroon tayong Napis versus Court of Appeals. Press period rule as a civil case. The press period rule merely provides that after the denial of your MR, you are given a press period to elevate the case to the next level court. Ito naman kaso ni Yu versus Tatad, na-convict yung akusado. After the conviction, nag-file siya ng MR. Dininay yung MR, pinakulong siya. Okay? So sabi ngayon, nung akusado, entitled ako. I am entitled to a press period of 15 days based doon sa Napis versus Court of Appeals. O sabi naman ng judge, hindi, civil yun. Criminal ito. So, he elevated the matter to the Supreme Court and per Mr. Justice Brion, the press period in civil cases also applies in criminal cases. Okay? Now, sabi ko sa inyo kanina, may kasong bago. 2022, February. Yung naunang kaso class, yung Anthony versus People, 2017 rape. Because under Section 3E ng 122, in relation to Section 13C ng 124, if the penalty imposed by the trial court is reclusion perpetua or life imprisonment affirmed by the Court of Appeals, in going to the Supreme Court, you merely file a notice of appeal. Ang nangyari sa Anthony, imbis na mag-file ng notice of appeal, nag-rule 45 siya. So it was denied outright by the Supreme Court. And the decision becomes final. Anthony is now in Muntinlupa. Okay, ganun yung nangyari. Now, pagdating ng 2022, as guidance for the bench in the bar, this is an in-bank decision, nagkaroon ng People versus Olpindo. Now, ano ang sinasabi dito? Okay, ang guidelines class ay ganito. Remember that the death penalty under RA 7659 was suspended. And as early as People versus Mateo, there is no more automatic appeal. Now, if you are convicted by the RTC, and the penalty imposed is reclusion perpetua or life imprisonment, how do you appeal? You merely file a notice of appeal within the 15-day period. Ngayon, kung umaasa ka na mayroong automatic review, because under the old rule, if the imposed penalty is death, reclusion perpetua, or life imprisonment, with or without notice of appeal, the RTC will elevate the case to the Court of Appeals, and if the judgment is affirmed, the Court of Appeals will not enter the judgment, but instead, he will certify the case to the Supreme Court for automatic review. That was the old rule. May bagong rule ngayon. Okay? Kasi wala ng death. Suspended. So kung reclusion perpetua life imprisonment, dapat mag-file ka ng notice of appeal. Hindi ka nag-file ng notice of appeal. If the record is elevated either to the Court of Appeals or to the Supreme Court within the 15-day period, the Court of Appeals or the Supreme Court, as the case may be, will notify the accused. If the accused is adopting the transmittal of the record as his notice of appeal within 10 days. Okay? So, isa. Okay. Pangalawa, if the record is elevated either to the Court of Appeals or to the Supreme Court after the lapse of the 15-day period, kasi nga, obligado na yung akusado na mag-file ng notice of appeal. After the lapse of the 15-day period, final na kasi. Then the judgment shall be entered. Wala na. Okay. Pangatlo, if the accused opted to file a Rule 45 petition, okay, ibig sabihin, within the 15-day period, MR niya denied, nag-opt siya na Rule 45. Aakyat niya Supreme Court. Now, only purely question of law must be raised by the accused. If the accused raise mixed question of facts in law, then it shall be dismissed. People versus Olpindo. as guidance for the bench and the bar. So covered yan ng bar exam by September. Tandaan nyo. Kasi it supersedes the case of Anthony versus People. Now, under the rules on statutory construction, in case of conflict between an old and a new decision, the new decision shall prevail, being the latest intention of the highest court of the land. Remember also that we have only one Supreme Court which all other courts must adhere to. Only the decision of the Supreme Court is authoritative. Kung ano sabihin ng Supreme Court, yun na yun. O hindi sa inyo yan. Makati, tagig yan. O yun na yun. MR mo, denied. O final na. Wala na. So take note. O sige. Dito na tayo. I think nakopya nyo naman. O makinig na lang kayo kung ayaw nyong kopyahin. Because some of my reviewees and students, I implore them na kopyahin ito. Wala akong estudyante na pumapasa sa civil or criminal procedure or remedial law 1 and 2 na hindi kabisado ito. Ito ang revalida nila para may baon sila pagdating doon sa bar examination. Okay. Now, if the crime committed is punishable by at least 4 years, 2 months, and 1 day, matter of right ang PI. Okay? So, kung nasa city ka, ipapile mo sa OCP. Kung ikaw ay nasa probinsya, ipapile mo sa OPP. Now, ibababa ngayon sa kanilang assistant. Okay? So, magkakandak ng PI. Question. Is the findings of probable cause by the assistant city or assistant provincial prosecutor appealable? Answer, yes. You can file a motion for recon within 15 days. Okay? Now, here comes DOJ Circular 018-14. 2017 ito. If your motion for recon is denied by the OCP or OPP and the crime committed is within the jurisdiction of the NTC. Okay? So, ibig sabihin, punishable by 6 years and below. You will go to the PG kung ikaw ay nasa Metro Manila. Kung ikaw ay nasa probinsya, pupunta ka ngayon sa RSP. What should you do? Petition for review within 15 days. Okay? Now, as a rule, the findings of the PG and the RSP is final and executory. Okay? But it does not preclude the Secretary of Justice from reviewing the findings of the PG or the RSP. Now, another one. If your MR is denied by the city prosecutor or provincial prosecutor and the crime committed is within the jurisdiction of the RTC, ibig sabihin, more than 6 years ang penalty. From the city or provincial prosecutor, you will go to the SOJ. Okay? Pursuant to DOJ Circular 70 and 70-A. Now, what should you do? Petition for review within 15 days. Okay. If the imposable penalty is reclusion perpetua or life imprisonment, your petition for review is denied by the SOJ, mayroon ka pang isang step. Okay? You can go to the OP by filing a memorandum of appeal within 15 days. Okay? So yan yung hierarchy. Now, the findings of the SOJ is final and executory. Okay? So, pagka reclusion perpetua sa life imprisonment, may isa pa. OP. Now, kapag ka less than reclusion perpetua or life imprisonment, final pagka na-deny ka. So, what should you do? You can go to the Court of Appeals. Rule 65. How many days do you have? 60. Extendable? Yes. Plus 15 equals 75. What should you do? Motion for extension plus payment of docket fee. Now, if the SOJ review the findings of the city or provincial prosecutor, he is merely exercising supervisory power under the 1987 Administrative Code. If the OP review the findings of the SOJ, OP is exercising quasi-judicial power. Okay? So therefore, the findings of the OP is appealable. What rule will you use? Rule 43. Saan ka ngayon pupunta? Court of Appeals. How many days do you have? 15. Extendable? Yes. Plus 15 equals 30. What should you do? Motion for extension plus payment of docket fee. Clear? Gusto mo pang questionin? Court of Appeals, talo ka. Bong Navarro case. Sikat na sikat yung kasong yon. You can go to the Supreme Court, Rule 45 ka. Purely questionable. So, tapos tayo dito sa piskal. Ito yung hierarchy ng sa public prosecutor. Okay? Punta tayo ngayon dito sa Ombudsman. Kasi limitado oras natin, hindi ako pwedeng babagal-bagal. Now, 27 and above. May conspiracy, kahit private, pwede, or below 27. Provided mayroong allegation of conspiracy. Example, Janet Lindapoles. Private siya, nakasama. Now, sabi natin, ipapile dito. Okay? So, ipapaba ngayon sa GI. Graft Investigator, magkakandak siya ng PI. Now, if the complainant did not inform the Ombudsman that there is another administrative case filed in a different quasi-judicial agency, then the Ombudsman will issue a twin resolution. Okay? Isang criminal at isang administrative. Example, yung police, mayroong napolcom o criminal na lang. But if you fail to inform, dalawa ang ilalabas nila. Question, is the findings of the graft investigator appealable? Answer, yes. AO number 7 as amended. Okay. Kapag ka criminal class, meaning may probable cause, you can go to the OMB by filing an MR within 5 days. Okay? Now, if it is administrative, you can go to the OMB by filing an MR within 10 days. So, magkaiba yung dalawa. Pagka criminal, 5 days lang ang MR. Kapag ka administrative, 10 araw. Okay. If your MR is denied by the Ombudsman in criminal case, the findings of probable cause, that is already final and executory. Therefore, you utilize Rule 65. Okay? So, pupunta ka, Rule 65, sa Supreme Court. So, 60, pwedeng mag-extend ng 15, equals 75. Pwede kang mag-file ng motion for extension plus payment of docket fee. Okay? Now, kapag ka administrative, denied yung MR mo, saan ka ngayon pupunta? Pupunta ka ngayon dito sa Court of Appeals. Anong rule ang gagamitin mo? 43. Mayroon kang 15, extendable sa 15, equals 30. Ano gagawin? Motion for extension plus payment of docket fee. So, magkaiba. Criminal, 65. Now, kailan ka ba nagsi-65? Memorize, there are 14 elements. There is no appeal, plain, speedy, adequate, remedy, in the ordinary course of law. 7. there is grave abuse of discretion amounting to lack or excess of jurisdiction. 7 uli. 14. Yan ang gustong mabasa ng examiner. Now, exception to the rule. In administrative cases class, if the penalty imposed is admonition, reprimand, fine, and suspension of not more than 30 days, final and executory. Okay? Now, you want to question the admonition, reprimand, or fine, o suspension of not more than 30 days. Sabi mo, ayokong mamantsahan ang pangalan ko. What should you do? You can go to the Ombudsman utilizing Rule 65. Because if the administrative penalty imposed is admonition, reprimand, fine, or suspension of not more than 30 days, it is final and executory. There is no appeal. 2022 bar examination question. Eksakto yung diniscuss natin dito. I think you can check it in the record of Rex. Last year. Okay. So, punta na tayo ngayon dito sa court. Madali lang. Anong sabi sa Section 2 ng 125? Basahin ninyo. Pareho lang ang appeal sa civil at criminal. Okay. Convicted ka ng MTC. So, kapag ka RSP, MR prohibited. Insofar, yung nagtanong kanina, insofar as decision, judgment, or resolution is concerned. Therefore, if it is interlocutory order, you can file an MR. Okay? MTC convicted. MR mo denied. Akyat ka ngayon. RTC. What should you do? Notice of appeal plus payment of docket fee within 15 days. So, nakapix. Tapos na naman yung 40 mo. Okay? So, more than 6 years yung imposable penalty. You file it with the RTC. Convicted ka. MR ka mo denied. May press period ka ngayon. You versus Tatad. Okay? What should you do? Akyat ka. Court of Appeals. Notice of appeal plus payment of docket fee within 15 days. Okay. Sabi natin, tapos na naman yung 41 mo. Yung RTC is not only a trial court, but it is also an appellate court. So, conviction ng MTC, affirm ng RTC. Aakyat ka ngayon sa Court of Appeals. Anong rule? 42. Kasi yung RTC, in the exercise of its appellate jurisdiction. Ano gagawin mo? Petition for review. How many days? 15. Is it extendable? Yes, plus 15 equals 30. What should you do? Motion for extension plus payment of docket fee. So, clear. Now, magkakaroon ngayon ng pagkakaiba doon sa Court of Appeals. Ano yon? If the penalty imposed is reclusion perpetua or life imprisonment affirmed by the Court of Appeals as a rule pursuant to Section 3E, Rule 122, in relation to Section 13C, 124. Doctrine of double appellate review. In going to the Supreme Court, you merely file a notice of appeal plus within 15 days plus payment of docket fee. Okay? Yun ang rule talaga. As guidance, kung nagkamali, you can utilize People versus Olpindo. Pero yung rule, affirm, notice of appeal lang. Now, what is the advantage? In notice of appeal class, the entire records will be elevated to the Supreme Court for review. In other words, not only question of law, but question of facts can be reviewed by the Supreme Court. Pero pagka Rule 45 ka, purely question of law lang yan. No. Klaro? So, clear tayo makakarating doon sa Supreme Court. So, if the penalty imposed is less than reclusion perpetua or life imprisonment, in going to the Supreme Court of Rule 45 ka. PQL ka. So, original 15 plus 30 equals 45. What should you do? Motion for extension plus payment of docket fee para magkaroon ka ng maximum na 45 days under Rule 45. Now, yung appeal sa Sandigan, originally filed, ulit na lang ito, originally filed, convicted, regardless of the penalty imposed, Supreme Court, notice of appeal. Ilang araw? 15. Okay? Plus payment of docket fee. Sandiganbayan, in the exercise of its appellate jurisdiction, ibig sabihin, galing RTC. Okay? Convicted. Affirm, reclusion perpetua or life imprisonment. Ano dapat ang rule? Section 3E, Section 13C ng 124. Dapat magpapile ka lang notice of appeal. Okay? Nag-opt ka, Rule 45, palo, people versus Olpindo. Purely question of law lang ang pwede mong erase. Now, if you raise mixed question of facts and law, i-dismiss yan. Okay. Court of Tax Appeals, tayo. 1 million. Okay? First, second, third. Natalo, convicted, convicted, convicted. Okay? Can you go to the Supreme Court? No. Petition for review within 15 days. Affirm ng bank ang conviction. Okay? Now, in going to the Supreme Court, Rule 45, PQL. Tapos ang lahat ng courts. May baon na kayo. Sigurado ko, mayroong itatanong dyan, imposibleng wala. Sa civil, saka criminal, may baon na kayo. So, I will now entertain questions sa criminal procedure. Outside criminal procedure, I will not answer. Okay? Kung labor yan o kung ano yan, hindi ko sasagutin. In deference to other bar reviewers. Any question? Rex, I will now entertain question. Tapos ko na to. Kung ano yung gusto nilang linawin. Any question? I-construe ninyo sa Rex. Sila ang magbabasa ng tanong. So, do you have any question? Dahil pakitutok yun. Alvin, may tanong ba?
So far po din, wala pa pong questions tayo from
wala pa.
stream.
Can we have a break of at least 10 minutes? Medyo exhausted na ako, tuloy-tuloy. Pwede ba tayo mag-break?
Pwede po din.
Sige. Resume tayo 5 to 4. Okay?
Okay.
Kung may tanong, basahin mo na lang, sasagutin ko. Pag
Yes.
may pumasok, okay?
Yes po din. To everyone watching, let's go back 5 minutes to 4. Just stay watching, keep watching. See you later.
Para ma-correlate natin. Okay? At least may baon na kayo. Now, we go to general matters at jurisdiction. So, what are the requisites to acquire jurisdiction in criminal cases? Okay, so there are 3. Number 1, jurisdiction over the subject matter. It is vested by law in the Constitution. Then number 2, jurisdiction over the territory where the offense was committed. Remember that in criminal cases, venue is jurisdictional. You file the case where the crime was committed, exception to the rule, in case of transitory offenses, meaning it travels from one place to another. Example, kidnapping. Another example, BP22, the check was issued in Baguio, in Quezon City. So in any of the place or places that it travels, you can file the criminal case to the exclusion of any other jurisdiction. So take note of that. Now, how about jurisdiction over the accused? There are 2 instances that the court can acquire jurisdiction over the person of the accused. 1, valid arrest. Either it is regular arrest under 113, or you are arrested under the exceptional circumstances, Section 5 of 113. What are these? Number 1, in flagrante delicto. When the crime was committed, or in the presence of the police officer about to commit or attempting to commit. Number 2, if the arresting officer has personal knowledge over the crime committed. And number 3, if you are a prisoner who escaped from jail. And number 2, that the court acquired jurisdiction over the person of the accused is voluntary surrender. Villa Gomez versus People, November 10, 2020, in-bank decision, Mr. Justice Ismundo. Now, I want to discuss also the case of Villa Gomez. What happened in the case of Villa Gomez? The information was filed before the RTC of Makati without the signature or approval of the city prosecutor of Makati, Prosecutor Aspe. Now, when the case was already submitted for decision, the judge all of a sudden issued an order dismissing the case on the ground of violation of paragraph 3, section 4 of Rule 112, which provides that no information or complaint shall be filed in court without prior conformity or approval of the city or provincial prosecutor. Now, they went to the Supreme Court. The Supreme Court made the guidelines again and reversed all other cases in conflict with Villa Gomez. Now, one of the case class was the case of Paquillo versus Tolentino. It happened in Camarines Sur. The RSP of Region 5 Tolentino conducted a PI for violation of the SSS law. After findings of probable cause, information was filed before the METC of Naga City. The accused filed a motion to quash because the information has no prior authority coming from the city prosecutor of Naga or Camarines Sur, and the information was dismissed. Now, in Villa Gomez, it reversed all other rulings. Now, what does it say? As long as the resolution of findings of probable cause has the signature or imprimatur of the city or provincial prosecutor, it is enough that the information is signed by the assistant city prosecutor. So yun ang bago. It is also a 2020 decision of the Supreme Court, and it is in bank. As I have told you, the information once filed in court, it will be at the total disposition pursuant to the landmark decision in the case of Crispo versus Mugol. So yung Villa Gomez, ni-reverse niya. I think at least 5 decision na dati kailangan may pirma, approved or by authority of the city or provincial prosecutor. Ngayon, maski yung assistant city na lang. Provided that the resolution of findings of probable cause with approval or imprimatur of the city or provincial prosecutor is attached to the record. Now, how can the court acquire jurisdiction over a given crime? So if it is a given crime case, it is vested by law upon a particular court that may be conferred by the parties involved in the offense. So, you cannot confer jurisdiction if you're a party. It is the court or it is the law that confer jurisdiction. Now, person of the accused, na-discuss na natin. Now, under 110, one of the crucial provision class is Section 5. Who must prosecute criminal action? All criminal action shall be prosecuted under the direct control and supervision of the city or provincial prosecutor or prosecutor for that matter. Now, there is a landmark decision na until now ay magandang decision pa rin. Okay? Now, the Philippines and the United States has a visiting forces agreement. Okay? So, there is always a military exercises between the AFP and the United States Armed Forces. Now, we know for a fact that if the American GIs or American servicemen dock in the pier, they will color the city red. At one time, nagkaroon ng military exercise, the warship of the US docked at the Subic Bay, former US military base. So, isa sa mga lulan niya ay si Pemberton. At that time, 23 to 24 years old, macho, gigulo, guwapings. While walking along Magsaysay Boulevard in Olongapo City, nakita niya ngayon, mawalang galang lang, si Jennifer na dating si Jeffrey. Okay, so nung nakita sila, sabi niya, nakita niya, mahabang buhok, maganda, sexy. Sabi niya, hey beautiful, you want to play jackstone? Sabi niya ganon. Akala siguro magja-jackstone, sumama. So nag-inuman sila. After nilang mag-inuman, nag-check-in sila sa Selson Lodge. So pagpasok nila ngayon sa hotel, naghubad na si Pemberton, naghubad din si Jennifer. Pagtingin ngayon ni Pemberton, may lawit. Pagtingin din niya sa baba niya, may lawit siya. Nagalit ngayon si Pemberton. Sabi ni Pemberton, hey, we will not be doing fencing here. So sa galit niya, sinabunutan niya si Jennifer, mawalang galang uli, isinubsob niya yung mukha sa inodoro. Patay. So a case for murder was filed and under the BFA in case an American GI committed a crime in the host country Philippines. If the crime committed is a non-bailable offense, pending trial, he shall be detained at the Marine Barracks in Taguig, Port Bonifacio, Taguig, Metro Manila. Now, the Council for Laudes filed a motion to transfer detention. Tama nga naman, because the crime was committed in Olongapo City. Ang sabi natin kanina sa general principles, where the crime was committed. However, it has no signature or prior conformity of the city prosecutor. Then, prior to the amendment of the 1997 Rules of Civil Procedure, Sections 4 and 5 provides that a motion with no notice of hearing is a mere scratch of paper. So there must be at least 10 days, 3 days notice rule. Now, received ng abogado ni Pemberton, it was denied outright by Judge Sene Sabalde. On certiorari to the Supreme Court said, number 1, that a motion without notice of hearing is a mere scratch of paper. Okay, I don't want to be misinterpreted. Under the amendments of the 97 Rules of Civil Procedure, Rule 15, a motion, whether litigious, it affects the substantial right of the other party, or non-litigious, it does not affect the substantial right of the adverse party, need not be set for hearing. Okay? So, ang still subsisting ay yung provision ng Section 5. The Supreme Court said that all criminal cases shall be prosecuted under the direct control and supervision of the public prosecutor. And therefore, the motion was denied. The rest is history. Okay? So, take note of Section 5, who must prosecute criminal action. Now, how about information? Under Section 4, in criminal case, the filing of the complaint or information in court initiate a criminal action. So if the question is asked, when is a criminal case initiated? It is the filing of the information in court. Villa Gomez versus People, November 10, 2020, in bank. Mr. Justice Hismundo. So take note of this case, baka itanong ngayon. When can an information or complaint be considered sufficient in form and substance? So if it contains full name of the accused, designation of the offense given by the statute, acts or omission constituting the offense, the name of the offended party, the approximate date and time of the commission, and the place of the offense, where the offense was committed. Now take note that qualifying and aggravating circumstance must be alleged in the information. Now, even if the qualifying or aggravating circumstance is proven during the trial, if it is not alleged in the information, it will not be considered because it is a violation of the right of the accused to be informed. People versus Natindim, November 4, 2020, Mr. Justice Hernando. Now, what is the purpose of the requirement? That the elements of the crime must be alleged in the information. This is class to enable the accused to suitably prepare his defense. Because under the Constitution, the accused is presumed to have no independent knowledge. People versus Eulalio, October 16, 2019. Now, how about prosecution of civil action? One of the crucial provisions is Section 1. Section 1, letter A, if the private complainant wants to institute an independent civil action, he must do so before the prosecution present its evidence. Now, this is pursuant to the provision of Article 100 of the Penal Code, that a person criminally liable is also civilly liable. However, there is an exception to the rule. Under letter B, Section 1 of 111, for violation of BP 22, upon filing of the information, the civil aspect is included. There can be no separate civil action for violation of BP 22, regardless of the amount. Yun ang pinag-iba nito sa civil. Sa civil, ang pinagbabasihan lang natin ay yung imposable penalty. So take note of that. Now, how about effect of death of the accused? Okay, ano ang rule? If the accused died while the case is pending, either on trial or on appeal, if the civil liability ex delicto of the accused is based on the crime committed, then the case shall be dismissed and the accused could not be held civilly liable. If there is any other source of the civil liability of the accused, then the civil liability survived even if the accused died on trial or on appeal. So therefore, if the case class is in the Supreme Court, and while the accused is already serving his sentence in the National Bilibid Prison, and the accused died, then the decision is not yet final and executory. Therefore, if it is not yet final and executory, then the liability of the accused, civil and criminal, is extinguished. Now, ano yung sinasabing other sources of civil obligation? So A obtained a loan from B Bank in the amount of 50 million. He mortgaged his mansion located at 12th Street in New Manila, Quezon City. The loan is payable for 5 years. He executed a promissory note, an REM, and issued a post-dated checks for the monthly amortization. Now, because of the pandemic, the business of A backed down. And he failed to pay the loan in the amount of 50 million. All checks that he issued bounced. Now, in the meantime, a case for BP 22 was filed with the MTC of Quezon City. While on trial, A died due to COVID-19. Question, will the civil liability survive? Answer, yes. For the reason that there is other sources of civil obligation. You have the PN, and you have also the REM. Martel et al. Versus People. Bautista versus People. February 2, 2021, in-bank decision. So, as what I have said, the decision of the division is also the decision of the Supreme Court. So, because the Constitution provides that no decision of the Supreme Court, either by a division or by a bank, shall be revised, reversed, or modified except through an in-bank decision. Therefore, an in-bank decision is more doctrinal in character, considering that 15 justices of the Supreme Court participated in the deliberation as presided by the Chief Justice. So take note of that. Now, prejudicial question. What is a prejudicial question? It is understood in law that which must precede the criminal action and which require decision before the final judgment can be rendered in the criminal action with which the question is closely connected. In other words, the findings in the civil case will affect the findings in the criminal case, or the criminal case will be dependent to what will be the result in the civil case. And therefore, the criminal case shall be suspended and you need to await the resolution in the civil case. In that case, there is a prejudicial question. Now, how about if in case of administrative case? Is an administrative case be considered a prejudicial question to a criminal case? The answer is no. For the reason that, as what we have illustrated, the Ombudsman, if you fail to inform that there is another administrative case filed in a quasi-judicial body of the government, the Ombudsman will issue a twin resolution. One for criminal and two for administrative. Okay, 112, determination of probable cause. There are two. You have executive determination of probable cause. This is the job of the prosecutor for purposes of filing an information in court. And also, judicial determination of probable cause. This is the job of the judge, pursuant to Article 3, Section 2 of the Constitution. BIR versus Kagang, March 16, 2022. Mr. Justice Hernando. Also, another case, Co versus Somerville, August 4, 2021. Mr. Justice Hernando. Distinguishing executive from judicial determination of probable cause. Now, remember class, that motion for judicial determination of probable cause is now a prohibited pleading under the revised guidelines on continuous trial in criminal cases, for the reason that it is the primary duty of the judge upon receipt of the information to determine whether there is a judicial probable cause for the issuance of warrant of arrest. Now, let us now correlate this para makarami tayo. 113, 126. 113 arrest, 126 search warrant. Question, can an MTC judge issue a warrant of arrest or search warrant for violation of RA 9165? Now remember that 9165 is punishable by more than 6 years. And the jurisdiction of the MTC is only 6 years and below. And therefore, it has to be filed with the RTC. In the case of People versus Castillo, the Supreme Court said that in the filing or application for a search warrant, there is no jurisdiction topic all about, or there is no issue of jurisdiction. The word judge, as used in Article 3, Section 2 of the Constitution, was used in its generic sense. And therefore, an MTC judge can issue a search warrant for violation of 9165. Ano nangyari doon? The IN or the Philippine National Police based in Tuguegarao applied for a search warrant before the MTC of the municipality of Gataran in Cagayan. After conducting a preliminary examination pursuant to Article 3, Section 2, and there was probable cause, the MTC judge issued a search warrant. It was implemented in Tuguegarao, Cagayan. It yielded positive the owner filed a motion to quash search warrant and it was denied. It went to the Supreme Court. The Supreme Court said that the MTC judge has the power as long as it complies with the provision of Article 3, Section 2. Okay. Effect of non-wearing of the body-worn camera or the new rule on BWC that took effect on August 1 of 2021. Insofar as 113 is concerned, the non-wearing of BWC by the arresting police officer will not affect the validity of the warrant of arrest without prejudice to the liability, administrative, or contempt of court of the arresting police officer either in the service of the regular warrant or pursuant to the warrantless arrest under Section 5 of Rule 113. Now, there is a difference if it is a search warrant, if the searching police officer did not wear a BWC without any justifiable reason, any evidence gathered shall be inadmissible as evidence pursuant to the doctrine of poisonous tree. Lifetime of a warrant of arrest versus lifetime of a search warrant. The warrant of arrest class remains outstanding until the accused is arrested, either issued by the MTC, RTC, Sandiganbayan, Court of Appeals, Supreme Court, and the Court of Tax Appeals. However, under Rule 126, the lifetime of a search warrant is only 10 days reckoned from the date of its issuance. After the lapse of the 10-day period, it becomes punctus officio and has no more force and effect. Now, effect of the BWC rule as regards to search warrant. Under the revised guidelines on pre-trial for executive and vice-executive judges and clerks of court, if the search warrant is applied by the director of the NBI in Manila and the search warrant is issued by the executive judge of the City of Manila or its vice-executive judges pertaining to heinous crime, it is implementable anywhere in the Philippines. The same thing if the search warrant is issued by the executive and vice-executive judges of Quezon City and applied by the director of the CIDG involving heinous crime, it is also implementable anywhere in the Philippines. Upon the effectivity of the rule on BWC on August 1, 2021, it is deemed abrogated. The extent of implementability of the search warrant is only good within the region. Exception to the rule if it is a violation of the IP law or intellectual property law. Okay, so isang bato, dalawa ang tinamaan natin plus special rule. Okay, we go to 112. Matter of right, if the crime committed is punishable by at least 4 years, 2 months, and 1 day. Remember the Moya III in criminal procedure. Kanina may nabasa ko while on break. Is motion for reconsideration raw necessary doon sa city or provincial prosecutor? Okay? I think tulog ka with due respect nung nag-i-illustrate ako. From assistant or ACP or APP, may probable cause, mag-EMR ka sa OCP or OPP. Okay? Within 15 days. Na-deny, papasok DOJ Circular 018-14, DOJ Circular 70 and 70-A. If the crime committed is within the jurisdiction of the MTC, pupunta ka sa PG. Kung ikaw ay nasa Metro Manila kasi wala namang RSP sa Manila. Prosecutor General. Pag ikaw ay sa probinsya, RSP. Ngayon, kung ang crime committed ay within the jurisdiction of the RTC, meaning punishable by more than 6 years, na-deny yung MR mo ng OCP or OPP, pupunta ka ngayon sa SOJ. Okay? Ngayon, may panibago uling layer. If the penalty or imposable penalty is reclusion perpetua or life imprisonment, may isa ka pa. Pwede kang umakyat sa Office of the President. Okay. Now, talo ka pa rin sa OP. 43 ka ngayon, baba ka sa Court of Appeals. Kung ang imposable penalty ay less than reclusion perpetua, life imprisonment, denied yung petition for review mo ng SOJ, galing SOJ, pupunta ka ngayon sa Court of Appeals, Rule 65. Now, mayroon pang time para mag-memorize tayo. Ginagamit mo yung 65 kapag present yung 14 elements. Ano yon? Uulitin natin. There is no appeal, plain, speedy, adequate, remedy in the ordinary course of law. 7. Now, another 7. There is grave abuse of discretion amounting to lack or excess of jurisdiction. Magro-rule 65 ka. Okay? So, maliwanag. If the Secretary of Justice review the findings of the city or provincial prosecutor, he is merely exercising supervisory power under the 1987 Administrative Code. If the OP review the findings of the SOJ, the OP is exercising quasi-judicial power, kaya under Rule 43. Okay? Klaro. So clear tayo. Now, PI. What is PI? A preliminary investigation is required before the filing of the information if the crime committed is punishable by at least 4 years, 2 months, and 1 day. Okay, correlate with the revised guidelines on continuous trial in criminal cases. Now, if you are arrested in flagrante delicto under 113 letter A, or in hot pursuit, under 113 section 5B, you have 5 days in order to avail your right to preliminary investigation if the crime committed is punishable by at least 4 years, 2 months, and 1 day. After the lapse of the 5-day period, it is now barred. Marsan versus People, October 11, 2021, Mr. Justice Hernando. Now, you want to read, may time pa kayo, okay? Regarding the resolution of the investigating prosecutor in its review under Section 4, you can read Wu versus People, March 16, 2022 by Mr. Justice Hernando. Kaya lang, sinurkat ko na. Okay? Kapos na kayo sa oras. For purposes ng bar examination, better I implore everyone that you can master the Moya III. Mayroon pa, ito naman yata nare-replay, i-replay ninyo. Kasi hindi ko na pwedeng ulit-ulitin. Ubus na ang oras natin. Okay? Now also, i-advertise ko lang that by next week, may pre-week in Remedial Law. Manipis lang. I hope kunin na naman doon like what happened in the previous years. Yung mga tanong para makatulong ako sa pagiging abogado at abogada ninyo. Okay? So read the case if you want. Yung sinabi ko kanina tungkol dito sa review ng resolution ng investigating prosecutor in the case of Wu versus People, March 16, 2022. Now, doon sa 113 class, what is crucial, also, i-discuss ko yung Section 4, Paragraph 3, Villa Gomez versus People, na binanggit ko na. It reversed the following decision of the Supreme Court. 1951, Villa versus Ibanez. 2004, Turingan versus Garpin. 2007, Tolentino versus Paquillo, yung diniscuss ko kanina. Kisay versus People, 2016. Maximo versus Villapando and Ongkiko, 2019. So, tandaanan, even in the absence of the approval by the city or provincial prosecutor, as long as the resolution of findings of probable cause is attached to the record with imprimatur of the city or provincial prosecutor, it is no longer a ground to quash the information pursuant to paragraph 3, section 4 of Rule 112. Okay? So, yung 113, memorize section 5, warrantless arrest in relation to the rule on BWC. Because the coverage class of the 2023 bar examination is up to June 2022. Now, BWC took effect on August 1 of 2021. And therefore, kasama pa rin yun. It effectively amended Rule 113 and Rule 126, including the revised guidelines of pretrial for executive judges and clerks of court. So take note of that. Now, issuance of a warrant and issuance of a search warrant are almost the same. There must be a judicial determination of probable cause. Merlina Diaz versus People, July 15, 2020, Mr. Justice Hernando. So determination of probable cause. Okay, we go to bail. General rule, all offenses are bailable. Exception to the rule. If the crime committed is punishable by reclusion perpetual or life imprisonment, it is a matter of discretion. Question, can you still avail your right to bail even if the crime committed is punishable by reclusion perpetual or life imprisonment? Answer, yes. There must be a strong or who has the duty to prove that you are not entitled to bail? It is the prosecution. Reason, you are presumed innocent. It is not the accused who will prove. Now, also, if you are convicted by the RTC, even if the penalty imposed is not reclusion perpetual or life imprisonment, it is now a matter of discretion. The case of People versus Libiste reverse the case of in reconviction of Judge Adoring Angeles. Now, what happened in that case? Judge Adoring was the presiding judge of Caloocan City. He was charged for 7610. Mayroon siyang mga minor na maid, umuwi ng madaling araw after ng day off, ginupit-gupitan niya yung buhok. Now, he was charged for violation of 7610, convicted by the RTC, prosecuted by the late Prosecutor Manny Velasco, former provincial prosecutor of Cavite. Now, Prosecutor Velasco went to the Supreme Court asking the Supreme Court to suspend Judge Adoring because of the conviction, utilizing Rule 114 that he was already or she was already convicted. Now, per Mr. Justice Natura, a constitutionalist, ano sabi? Even if the accused is already convicted, if the case is on appeal, the presumption of innocence prevails. That was the prevailing doctrine until the case of People versus Libiste. Libiste, for all you know, mayroon siyang best friend binaril doon sa Makati. First thing, ang kaso ay murder, lower down to homicide. He was convicted by the RTC of Makati. Sabi ngayon ni Libiste, mayroon nga kaso si Judge Adoring na-convict din di naman life, di naman reclusion yung ano ko. Ano sabi ng Supreme Court? It is a matter of discretion on the part of the court. Okay, kinds of bail. Ano ba yung mga klase ng piyansa? 1, surety bond. 2, property bond. 3, cash bond. Now, where do you post your bail? If issued by the MTC, arrested outside of its territorial jurisdiction, example, Bukawi, na aresto ka sa Malolos, you can post your bail either in the MTC or in the RTC. Okay? Now, warrant of arrest issued by the RTC of Manila, arrested outside Metro Manila. Okay, general rule, you need to post your bail with the RTC in the place where you are arrested. Now, can you post it in the MTC for your temporary liberty? Only in the absence of an RTC judge. Okay. If issued by the Court of Appeals, Sandiganbayan, or Court of Tax Appeals, Court of Appeals, mayroong Cebu, mayroong Cagayan de Oro. General rule, kailangan mag-post ka muna doon sa Court of Appeals. Exception to the rule, doon sa RTC. How about Court of Tax Appeals? Iisa lang, sa Quezon City lang. How about Sandiganbayan? Iisa lang sa Quezon City. How about Supreme Court na cite ka for contempt? And a warrant of arrest was issued against you. Where can you post your bail? Only in the Supreme Court. Okay? So clear tayo doon sa bail. Matter of right, matter of discretion. Wag na natin i-discuss yung kaso ng Attorney Gigi Reyes versus People in Sandiganbayan, that if there is violation of your constitutional right to speedy trial, you can utilize Rule 102. Hindi naman kasi kasama yun sa coverage. Just in case magtanong, what will be your remedy? Now, remember class that the Supreme Court also issued a decision in the case of Kagang versus Sandiganbayan. What is the predecessor of Kagang? It is the case of Tatad versus Sandiganbayan. That if there is a violation of your right to speedy disposition, it is a ground for motion to quash in addition to the provision of Section 3 of Rule 117. So, speedy trial in Kagang applies only in criminal cases. Speedy disposition applies in civil, criminal, or administrative. By the way, how many days does the public prosecutor have, or even the ombudsman, to resolve a case after the case is submitted for resolution? Under 112, it has only 10 days. After the lapse of the 10-day period, you need to file a motion for early resolution. Question, if you fail to file a motion for early resolution, does it mean that you already waive your right to a speedy disposition of your case? Answer, no. What is your remedy? You can file a motion to quash where the information was filed. Okay? Now, let us discuss also Enrile versus Sandiganbayan and People. Dalawang kaso kasi ito. It also applies to Rule 12 of the Rules of Civil Procedure on bill of particulars. So, ano nangyari sa Enrile? A case for plunder was filed against Enrile, Attorney Gigi Reyes, Janet Lim Napoles et al. Now, before the arraignment, Enrile filed a motion for bill of particulars or motion for a more definite statement under the federal rules of criminal procedure of the United States. Now, it was denied by the Sandiganbayan. According to the Sandiganbayan, it is not applicable in criminal cases. MR denied and really went to the Supreme Court. What does the Supreme Court said? Because according to Enrile, whenever he will fetch Attorney Gigi Reyes, he is 1.5 arm length away from them. Number 2, he is deep bingi. And number 3, he is playing with his stub. So, what was the Supreme Court said? The Supreme Court said that bill of particulars is also equally available in criminal cases as provided for in Rule 12 of the 97 Rules of Civil Procedure as amended. Now, another case. In that case also, Enrile filed a petition for bail. Now, the bail was denied by the Sandiganbayan. MR denied. Then Enrile went to the Supreme Court. And the Supreme Court ordered the Sandiganbayan to grant the bail of Enrile on humanitarian consideration. But in addition to that, because it was penned by Mr. Justice Bersamin, if I'm not mistaken, dalawa lang na justices sa Supreme Court ang laging nag-aano ng mga malalaking kaso. It's either Justice Dadong Peralta, my former professor, and also Chief Justice Lucas Bersamin. Now, in addition to that, mayroon pa kasing dahilan yung Supreme Court. Number 1, Enrile has a proven integrity. Enrile has a proven loyalty. If you still remember, there was a case filed against Enrile during the time of Cory Aquino. And that was rebellion complex with murder. What does the Supreme Court said? Enrile surrendered to the NBI. At that time, the NBI director was General Alfredo Lim, my former client, and Mayor of the City of Manila. Now, ano sabi ng Supreme Court? As early as in the case of People versus Rojas, there is no such case as rebellion complex with murder. Because if it is rebellion, there will be killing in the streets. Hindi naman kurutan, hindi naman sampalan yun. Okay? So, nag-surrender ngayon si Enrile. So, he has proven loyalty and proven integrity, and not only for humanitarian consideration. Now, mayroon namang isang bago ngayon. When can a party, accused or person, be released on recognizance under Section 15? Now, the Supreme Court class in the case of Marsan versus People, October 11, 2021, the accused can be released on recognizance under RA number 6036, PD 603, and PD 968. Under Section 16 of 114 of the rules of criminal procedure. It explicitly provides that a person in custody for a period equal to or more than the minimum principal penalty prescribed for the offense, charged without application for the ISL or in the indeterminate sentence law, or any modifying circumstance shall be released on a reduced bail or in his own recognizance. In other words, if the period, the imposable penalty has already lapsed, the accused has been incarcerated more than to the penalty to be imposed in case of conviction, then the accused can now be released on recognizance. So take note of the case of Marsan versus People, October 11, 2021, by Mr. Justice Hernando. Okay. Arraignment. We go to 116. Arraignment class is mandatory. Okay? Now, yung 116, lulukso yan sa 118 pre-trial. Because under the revised guidelines on continuous trial, after the arraignment, there will be pre-trial. Now, can you waive the arraignment? Now, the answer is yes, under the revised guidelines on continuous trial in criminal cases. But the judge is duty-bound to ask the accused as to whether or not he fully understood the information against him. The judge is duty-bound to propound questions to the accused. Naiintindihan ba niya? In other words, searching question to the accused is required. Now, under the revised guidelines, after the arraignment, pre-trial follows. 118 shall be correlated with Rule 18 in civil cases. 118 in criminal case. Pareho silang ending sa 8. It is mandatory. What do you do during the pre-trial? Stipulation of facts, definition of the issues, marking of documentary exhibits, definition of the issues, number of witnesses to be presented. Now, remember that under the Judicial Affidavit Rule, MTC, RTC, Court of Appeals, Sandiganbayan, Court of Tax Appeals, everyone is now enjoined to submit your JA to serve as the direct testimony of your witness or witnesses. In other words, 50% of the time for trial on direct examination is now barred. So, you need now, when you become lawyers by December, you need now to hone your talent in cross-examination. Radasa versus Sandiganbayan, August 4, 2021. Now, People versus Pagal was already asked in the 2022 bar examination. This is an in-bank decision by Mr. Justice Inmundo. Now, be that as it may, ano ba sinasabi dito sa Kagang? Kasi nandito tayo sa arraignment. If the accused entered into an improvident plea of guilty to a capital offense, it is the duty of the judge to ask searching question and to ask the prosecution to present evidence to prove the guilt of the accused beyond reasonable doubt. Now, what happened if the accused was convicted based solely on the improvident plea of guilty? And on appeal, the appellate court is duty-bound to remand the case to the trial court and order the prosecution to present evidence to prove the guilt of the accused beyond reasonable doubt, and also ask the accused whether the accused will be presenting evidence on his behalf. If despite time given to the prosecution failed to present evidence to prove the guilt of the accused beyond reasonable doubt, then the accused must be acquitted. Okay? People versus Pagal, review lang natin. It was asked in the 2022 bar examination. Eksakto. I also discussed that last year. Okay? Now, 117, motion to quash. Memorize Section 3 of Rule 117. General rule. If you failed to file a motion to quash before arraignment, it is deemed waived. Exception to the rule are those provided under Section 3, letter A, B, G, and I. Number 1, that the facts does not charge an offense. Okay? Number 2, that the court trying the case has no jurisdiction over the crime committed, then you have letter G, that the criminal action is extinguished or barred by prescription. And H, A, B, G, and I, that the accused has been previously convicted or double jeopardy. So, A to I, ang grounds mo. General rule, if you fail to file a motion to quash, it is deemed waived. Exception to the rule, A, B, G, and I. Now, even if you failed to file, it is not barred. You can always raise it. Double jeopardy. No persons can be put twice in jeopardy. That is a constitutional right. If the crime is barred by prescription, remember that the prescriptive period is governed by Article 1991 of the Revised Penal Code. If it is a mala inse crime, and if it is mala prohibita, special law, city or municipal ordinances, it is governed by Act number 3326, pursuant to the case of Jadeville Parking System versus Judge Lidua. So take note of that. Now, another ground class for motion to quash or motion to dismiss, as enunciated in the case of Kagang versus Sandiganbayan, is inordinate delay. In other words, as what I have stated, under Section 4 of Rule 112, if the case is submitted for resolution either in the office of the city provincial prosecutor or before the office of the Ombudsman, the office of the Ombudsman or the office of the city or provincial prosecutor has only 10 days. Now, in that case, you can file a motion for early resolution. Okay? Now, as respondent in the preliminary investigation in the Ombudsman, is it the duty of the respondent to follow up his case? Because this was the issue in a case filed with the Ombudsman. Because when the accused filed a motion to quash information invoking inordinate delay, it was denied. Because accordingly, he failed to file a motion for early resolution in the Ombudsman. In the case of Saldivar Perez versus Honorable First Division of the Sandiganbayan, November 13, 2019, Mr. Justice Hernando, the Supreme Court said, it is not the respondent's duty to follow up on the prosecution of his case. It was the office of the Ombudsman's responsibility to expedite the same within the bounds of reasonable timeliness in view of the mandate to promptly act on all complaints lodged before it. So, this is the case, class. Take note, Saldivar Perez versus First Division of the Sandiganbayan, November 13, 2019. So, take note of that. Dito sa 117, I already discussed 118 regarding pre-trial. Okay? Then also, memorize A, B, G, and I. Now, provisional dismissal. If the case, class, is filed with the RTC, 2 years, MTC 1 year. After the 2-year period, provisional dismissal, it becomes permanent. Now, in the MTC, 1-year provisional dismissal, the prosecution failed to revive. It becomes permanent. Now, what was the previous ruling? This is the case of People versus Lacson, class. And this is the Curatong Baleling incident. Reiterated in the case of Los Baños versus Pedro, an in-bank decision, citing the case of People versus Lacson. Now, is the absence of probable cause ground for motion to quash? The answer is no. The absence of probable cause is not a ground for motion to quash information. Rule 112 of the 2000 Rules of Criminal Procedure provides that the prosecution of offense or a criminal action is instituted upon the filing of the complaint with the prosecutor's office for the purpose of conducting PI, as may be required. Now, A judge cannot reverse the findings of the prosecutor during the PI and motu proprio quash the information for lack of probable cause. In case of doubt on the existence of probable cause, the judge may simply order the prosecutor to present additional evidence. Wu versus People, March 16, 2021. Mr. Justice Hernando. Okay? So, maliwanag tayo. Na-discuss ko na 113, 126. Okay. Amendment. Now, amendment class is a matter of right before the accused enters his plea. It is a matter of discretion if it is a matter of discretion after the accused enters a plea. Exception to the rule. What is the exception to the rule that even if the information will be amended, it is still a matter of right on the part of the prosecution. This is under the doctrine of supervening event. A stabbed B 27 times. He was caught in the act. The information for frustrated murder was filed against A. A was arraigned. After arraignment, 3 weeks thereafter before the first initial trial, B died. Question. Can the information be amended from murder, from frustrated murder to murder? Without violating the right of B or the right of A as the accused? The answer is yes, because it is a supervening event. The immediate cause of death of B is the stabbing incident. Now, pre-trial agreement, the pre-trial agreement as a rule must be signed by both the accused and counsel. The pre-trial agreement to be adopted by the court as the pre-trial order will govern the trial. Remember that in the pre-trial order, it is stated how many witnesses will you be presenting, what are the documents presented. The admission or stipulation of facts is already stated therein. Without justifiable cause, you cannot introduce any other unmarked evidence or not named witness therein. So take note of that. Okay? Now, trial in absentia. When can there be trial in absentia? After the accused arraignment and the accused jumps bail, then there will be trial in absentia. Now, can the accused regain his right to appeal in case of conviction after trial in absentia? The answer is yes. Provided that the accused reappear within the 15-day period or before the finality of the judgment with justifiable reason. Absent any justifiable reason, then it is deemed forfeited. Now, isa sa kaso na minention ni Justice Hernando ay yung kaso ng People versus Serio in Lacanilao. It affects section or Rule 23 up to 28 in relation class to Rule 119 as to whether or not deposition applies in criminal cases. Now, prior to People versus Serio in Lacanilao, there was a case, Go et al. Versus People. Ano yung Go et al. Versus People other deceits? Filed with the NTC of Manila. Now, because of several postponement, the private complainant went to Laos, Cambodia, okay, for medical treatment. Now, the prosecution filed a motion to take deposition, granted by the NTC, reversed by the RTC, then revived by the Court of Appeals, but denied by the Supreme Court. For the reason that there will be denial on the part of the accused to confrontation. So, 2012 until the case of People versus Serio in Lacanilao was promulgated by the Supreme Court in October 9 of 2019 per Mr. Justice Hernando. Ano ba nangyari dito? Now, Mary Jane Veloso is a lash from Nueva Ecija. He was recruited to work in KL in Kuala Lumpur, Malaysia. Now, upon arrival in Kuala Lumpur, Malaysia, she was told that the employer was out of the country and she need to exit to Indonesia. Remember that members of the ASEAN countries, we don't need any visa, provided you comply with the period to stay in the said foreign country. Now, she was told to exit in Yogyakarta, Indonesia. And she was asked by the counterpart of Serion Lacanilao in KL to bring with her a luggage. Without asking what was inside the luggage, Mary Jane went to Yogyakarta. Upon arrival in the Yogyakarta International Airport, she was apprehended by the immigration police. Later on, it was found out that inside the luggage was cocaine. She was prosecuted for illegal trafficking of drugs. She was convicted and sentenced to die by firing squad. Now, the Philippine government through the Foreign Affairs, Department of Foreign Affairs in PDEA made some representation. President Duterte also called up President Widodo if Mary Jane can be given a reprieve. Now, it was granted. In the meantime, a case for illegal recruitment, estafa, and violation of the Migrant Workers Act was filed with the Prosecutor's Office of Nueva Ecija. After findings of probable cause, the case or the information was filed with the RTC of Santo Domingo, Nueva Ecija. The prosecution filed a motion to take deposition, granted by the RTC, reversed by the Court of Appeals. On certiorari to the Supreme Court granted the taking of deposition of Mary Jane. Now, what was the reason of the Supreme Court? Because there was a condition issued by the Indonesian government. Number one, only the judge will be asking question and will be inside the prison cell. Only the judge and Mary Jane. No recording, no TV, no whatsoever, except the two. The Supreme Court said that the right of the accused to confrontation will still be protected because the cross-examination question will be in writing to be propounded by the judge. And therefore, the judge will be given a first-hand information. He will see what will be the mannerism, the way Mary Jane will be answering the question. So, the right of the accused or the constitutional right of the accused to confrontation will be protected. Now, also the most important one, class, the Supreme Court said that the testimony of Mary Jane will be akin to a dying declaration. Now, dying declaration is one of the 13 exceptions under the hearsay rule. In dying declaration, you can no longer cross-examine the accused or the witness, considering that he is already dead. However, in the case of Mary Jane, the accused's right to confrontation is still protected. And therefore, it is allowed. Now, I bank that the case of People versus Serion Lacanilao, October 9, 2019 by Mr. Justice Hernando will be asked either in Part 1 or Part 2 of Remedial Law. Okay? So, take note of that. 120, 121, 122, 123, hindi kasama. Demure to evidence, I already discussed this, with or without leave of court. One of the most important provisions, Section 23 of 119. 124, I already discussed doon sa Moya 3. Ang importante lang doon, class, doon sa 122, Section 3, E, Rule 122. 124 naman, Section 13, C of Rule 124. Remember also, the case of People versus Olpindo. Para hindi kayo malito, tandaan na ninyo yung tatlong rule. Okay, promulgation of judgment. Take note that there are only 3 instances that the presence of the accused is required. Number 1, arraignment. Number 2, promulgation of judgment. And number 3, if the accused will be identified by a witness. Other than that, the accused can waive his appearance. Now, how many days does the RTC or MTC have in order to promulgate a judgment? Under Article 8 of the Constitution, MTC has 90. RTC has also 90 days. Reckon from the date that the case is submitted for decision. Now, you need to distinguish Sandiganbayan, Court of Tax Appeals, Court of Appeals, if they are exercising their jurisdiction as a trial court. Kasi trial court din sila. There is a trial in the Court of Appeals in case of newly discovered evidence or as ordered by the Supreme Court for further reception of evidence. Then in the Sandiganbayan, it is also a trial court. And also the Court of Tax Appeals. There are 3 divisions therein. Exercising as a trial court, they have 90 days. Exercising as appellate court, they have 12 months. Supreme Court has 24 months. Question. Are the periods therein mandatory? Answer, yes, insofar as the first, second level courts and the 3 appellate courts. However, insofar as the Supreme Court is concerned, it is merely directory. Now, in the case of Inolba, Inalbes or Inolba et al. Versus Justice Teresita Leonardo de Castro, through Mr. Justice Leonen, the Supreme Court said the 24-month period is merely directory and not mandatory. What happened in that case? A 123 hectares of land formerly owned by spouses Elihio Malyari, where they bought it from PNB, was also sold to the group of Inolba. Now, there was a case between Malyari and PNB that is already 5 years in the Supreme Court. Upon learning that the case was assigned to Justice Teresita de Castro, Inolba filed an administrative case against Justice Teresita de Castro for non-compliance of the constitutional provision. So it was assigned to Justice Leonen. The Supreme Court said that the 24-month period as provided for by the Constitution is merely directory and not mandatory. Okay? Now, new trial and reconsideration. New trial, newly discovered evidence ang ground mo. Reconsideration, misapprehension of facts. Misinterpretation of evidence. What happened? What happened if the conviction is reversed? What happened to the evidence presented in court? The evidence is intact. So, new trial, newly discovered evidence. What is a newly discovered evidence? It is an evidence which could not have been presented during the trial with good faith on the part of the offeror. So, affidavit of good faith is necessary. Now, as regards to 122, who may appeal? So, what is provided that any of the parties may appeal, but there is a qualification, provided that the accused will not be put in jeopardy. So, People versus Mariano, February 28, 2022, Mr. Justice Hernando. This is also violation of 9165. So, 124, I already discussed how to do the appeal. 125, in going to the Supreme Court, isa lang. Take note of Section 2 that the appeal in criminal case and civil cases are the same. Okay? Now, 126, search and seizure, I already discussed together with Rule 113. 127, provisional remedy. Writ of attachment. Take note, class, that the writ of attachment is provided for by Rule 57. It is merely a provisional remedy. Okay, tapos ko ang CrimPro. May isang oras pa ba? Alin? May 1 hour pa ako? Alin? May 1 hour pa ba ako?
Meron pa naman.
Ako. 240 kilometers na yun, ha? Yung takbo ko kanina.
Mukhang busog na po lahat na nakikinig. Ganda ng lecture po, dire-diretso. Actually. Ang ganda po ng lecture po, dire-diretso at na-summarize po everything from
di ba hanggang 6 naman ako? Hanggang 6, 3 hours lang.
3 hours lang. Until 5 lang po tayo din, but we still have questions. We still have questions naman po, so we can accommodate the questions that the people who are watching the Facebook Live.
Okay. Kasi ganito, doon sa civil procedure, kaya inuna ko yung crime kasi may mga bagong doctrine na possible itatanong talaga. Now, tulad ng People versus Serio, ang coverage niya, Rule 23 to 28. Kaya I implore barristers, huwag na kayong pakaseryoso doon sa deposition. Ibinigay na sa inyo nung chairman yung itatanong. Yung People versus Serio. Kaya ni-recite ko na yung facts, ni-recite ko na yung ruling. Tingnan ninyo. Isang bato, 3 ibon ang tinamaan. Ano yun? 23 up to 28. Pangalawa, Rule 119. Pangatlo, Rules of Evidence. Akin to a dying declaration. So, sigurado ko, ilalabas yun. Now, yung Olpindo, sigurado ko, ilalabas yung bakit? Bago yun. Abogado nga, ibang abogado nga, hindi pa alam yun. When I conducted an MCLE lecture, hindi, pwede ba yun? Now, doon sa civil, may mga na-discuss na akong pinagdugtong-dugtong ko na. Tingnan ninyo. Tingnan ninyo yung Section 1, Rule 9. Tingnan ninyo yung Section 12, Rule 15, letter A, 1 to 3. Pareho lang yun. Tingnan ninyo yung Section 6, Rule 7. I-correlate nyo ngayon sa Section 10 ng Rule 18. Then, i-correlate nyo sa 34 and 35. May masasagot na kayo doon. Yung dito na lang sa Moya 3, lumabas lang 3 hanggang 5. Okay? Magpapasalamat na ako, may contribution na ako sa inyo sa pagiging abogado ninyo. And I want to see everyone watching in the PICC comes December. Okay? Maraming salamat sa Rex. Maraming salamat sa PALS for the opportunity to impart my limited knowledge in remedial law. Okay? Maraming salamat.
Thank you po, Dean. But we still have some few questions po, Dean. Is it okay if we
Yes.
if you can... Yes po.
Oh.
So we have a question here. Pero I guess nasagot nyo na po to. Dean, in cases you already lost your ready of appeal from the judgment of MTC, what is the remedy thereafter?
Okay. Pagka na-convict ka ng MTC, may 15 days ka rin para mag-file ng notice of appeal. Now, yung sabi ko kanina, pagka covered ng RSP, bawal ang MR pagka-judgment, final order or resolution. Interlocutory, hindi bawal. Ngayon, hindi ka nakapag-file ng MR. Okay? Hindi ka rin nakapag-file ng appeal. So, naging final and executory. Now, supposed to be, kukulong ka na. Ngayon, may remedy ka pa ba? Answer, yes. Pwede kang mag-apply ng probation if the penalty, kasi, di ba ang jurisdiction ng MTC, 6 years pababa lang naman. First time offender ka, good moral ka naman, wala ka namang ibang atraso, mag-probation ka para di ka makulong. Otherwise, makukulong ka. Okay?
Okay po. Thank you po, Dean. Next question po. Din yung sa review ng SOJ, pwede po ba i-review through Rule 65 kahit hindi na mag-review to CA?
Okay, yan ang ginawa ni Bong Navarro. Basahin nyo yung Bong Navarro case. Although hindi kasama yun sa coverage. Yan ang ginawa. Kasi class ganito. Di ba mayroon kasing DOJ Circular 018-14 2017 na kapag ang jurisdiction ay MTC, hanggang doon ka lang sa PG, kung Metro Manila ka, Prosecutor General, or Regional State Prosecutor. Pero, may nakalagay kasi doon sa rule without, it does not preclude the Secretary of Justice to review their findings. Okay? So, motu proprio pwedeng iakyat. Now, pagdating naman sa 70, saka 70A, galing ka sa city or provincial prosecutor, denied yung MR mo, ang jurisdiction ng crime ay sa RTC, ibig sabihin, more than 6 years, akat ka ngayon doon sa Secretary of Justice. Ngayon, may isa pa kasing layer. Ang sinasabi, if the imposable penalty is reclusion perpetua or life imprisonment, may isang layer ka pa. Pwede kang mag-memorandum of appeal sa OP. Ngayon, affirm pa rin ng OP. If the OP exercise the review power over the SOJ was a Judicial 43 appealable. Okay? Now, pwede ba na galing ka sa SOJ o denied yung petition for review mo? MR mo denied. However, the crime is punishable by reclusion perpetua or life imprisonment. Pwede ka bang pumunta sa Court of Appeals? By all means po pwede. Bakit hindi? Pero pwede kang maging liable for non-exhaustion of administrative remedies. Di ba? At your own risk. Malakas yung loob ng abogado. Hindi napansin. Kung napansin, paano nangyari kung kay Dilima? Di ba? Nakita, ba't hindi ka pumunta sa Court of Appeals? Bakit sa amin agad? Bakit? Porque ba senador ka? Ay kinakailangan, priority ka? Di ba si Katarungan nakapiring? Hindi ka nakikita, ano dala niya? Timbangan saka espada. Pag nagkamali ka, tatagpasin yung liig mo. Ganun lang yun. At your own risk pag naging abogado ka. Pero I would advise, you follow the hierarchy. Baka makontem ka. Remember, Section 3 of Rule 7. Once you sign the pleadings, kasama mong magiging liable solidarily ang kliyente mo. Okay?
Okay. Thank you po, Dean. Last question po. Is an MR necessary in a resolution of an assistant city prosecutor or assistant provincial prosecutor before appeal to prosecutor?
Yes. MR is a condition sine qua non. MR is an appeal. Di ba? Nakita natin yung illustration sa Ombudsman. Natalo ka sa GI. Saan ka nag-MR? Ombudsman. Na-deny ng Ombudsman. Saan ka pupunta? Pupunta ka ngayon sa Supreme Court. Now, MR is a condition sine qua non because it is an immediate remedy. Okay?
Yes, Pudin. Thank you, Pudin. I think that's all the questions that we have gathered from the Facebook Live viewers. Thank you so much for your time and for the lecture na summarized and very concise, Pudin.
Okay, salamat. Bye-bye. Good luck sa mga bar examinees. See you all in court. Bye-bye.
Yes, thank you so much, Dean Moya, for a summarized version of the civil procedure and the criminal procedure. Now, I would like to announce our upcoming schedule for Wednesday and Friday, both at 2 p.m. On Wednesday, it will be commercial law with Dean Nilo Divina, again at 2 p.m. And then on Friday, that's civil law, property and persons and succession with Dean Nenita H. De La Cruz Tuazon. That's Friday, 2 p.m. And then the following weeks, we will still have sessions from on Mondays, Wednesdays, and Friday. We would like to thank Rex Education and the Philippine Association of Law Schools for this wonderful pre-week lecture series that I guess everybody enjoyed listening. I think punong-puno na tayong lahat sa pakikinig kay Dean Moya, and we're very grateful for this opportunity. Thank you so much for everyone who has viewed our Facebook Live, everybody who sent your questions. Thank you so much for joining us, and I hope we see you again on Wednesday and on Friday and on the succeeding weeks. Thank you so much, and I hope you have a great day. God bless you all, and good luck.